Make legal also. I'm praying for listing of a contempt case, my lord.
Pending matter.
Pending matter,
Go to the registry.
my lord.
Pending matters, please go to the registry.
Lordship, I'm praying for listing of a fresh IA, Lordship. The connected matter is already listed tomorrow, Lordship, before it is honorable. Maybe the matter may come up tomorrow, Lord.
May I please? I beg to mention, my lord, item number 55. In this case, the government has filed affidavit last week, my lord. We need to file the reply. So 55. We need to file reply, my lord. They have filed the affidavit in opposition last week.
Okay. They filed it when? Yesterday?
Last week.
Last week. Mr. B. Professor, learned counsel for the petitioner, submits that the Elementary Education Department has filed affidavit in opposition last week. He is accordingly granted
2 weeks time to
3
file.
weeks time to file affidavit in reply.
Obliged.
This is the matter of the thing. Wait, is there any private respondent?
I've informed them.
Huh?
Already informed.
Already informed. This is the matter of the thing.
May please the Lordship. Lordship, I beg to mention for listing, my lord. My lord, for listing writ petition number 4973 of
Go to the
24, my lord.
registry.
My lord, similar matter situated already tomorrow listed, my lord. Item number 2, my lord.
What is the matter about?
My lord, alleging for the headmaster, my lord, after the amalgamation with high school, my lord.
In that item 2, are you a party?
Yes, my lord.
In item 2, you are a party.
Yes, my lord.
And in
Similar
this
matter, my lord. Tomorrow listed.
similar
Yes.
matter, what do you mean similar? In item 2,
Yes,
who filed item 2?
Item, my
Who
lord.
is the petitioner in item 2?
Petitioner, my lord, Monish Bhattacharya, my lord.
And in this matter that you want listed, who is the petitioner?
Enis Mazarbia, my lord, my senior.
Yes, madam.
May I please, Lordship? May I please, I beg to mention listing AI case, which is filed, which is fixed, sorry, filed today, is being filed today, with the IPC case number 11100.
IPC?
Sorry, WPC number 100525,
You filed an IA.
Lordship.
You want today?
Lordship.
Have you filed it? What is the filing number?
Right now,
You file it first, madam. Don't.
but WPC is fixed for tomorrow,
Okay, WBC.
and it's connected
Okay,
with this.
okay. Then it's okay. What is the petitioner's and in the case that you want listed tomorrow?
Yes.
What is the name of the petitioner?
Enis Mazar. Aji, Ranjan Rai, my lord.
Go to the registry.
Item 67 for withdrawal.
Miss?
Miss J. Akhtar, Lordship. With
Miss-
liberty, Lordship.
J. Akhtar, learned counsel for the petitioner, submits that she has been given instructions by her client, by the writ petitioner, to withdraw the writ petition.
With liberty, Lordship.
Why liberty? Why liberty?
Lordship, fresh filing, so
Huh?
fresh filing, Lordship.
With liberty to file a pay. Madam, you there?
67.
SSA is there, madam.
Huh?
SSA is there, madam.
Mr. S. Bora appears for
SSA, madam.
SSA. The prayer of the petitioner's counsel is allowed. This petition is dismissed as withdrawn, with liberty of appeal.
Item 1 for motion.
6 for instruction, lordship.
Supposed to submit what may be written instruction I received.
You file affidavit there.
Lordship will issue notice and
Right, Mr. S. Bora, learned counsel for the petitioner who submits that the petitioner has not, that the petitioner's husband,
Yes, Lordship.
husband.
petitioner's husband died in harness.
No,
Huh?
That is not the way, my lord. He expired during his service, my lord.
Expired during his service means
Lord-
died in harness.
Lord-
What do you mean no?
yes.
You all don't know. Died in harness while working as
Lordship, he was
Reader in the Assam University.
a reader in the Assam University. The petitioner prays for release of. What is this? 24 lakhs is for what?
24 lakhs is the portion which is Assam, he worked in Assam government. That has been already been released to the,
pro rata pension, Lordship, that is in,
already released to the Assam University and they are not releasing it.
This is for the pension.
That is for the pension other gratuity for the period 21/8/87 to 10/10/2007.
Whatever I said.
That has been already been released. Madam.
Release of rupees 24,90,982, which is the pension that has been pension, the proportion of pension
By the
paid by the Assam
Assam-
University, Assam
Assam government.
Assam government to the
Assam University.
Assam
And it released
University.
to the petition.
However, the same has not been released by the Assam University. That's all. That's all.
That's all and other family pensions, madam, by the Assam government for working the.
So, besides the above, family pension has not been paid to the petition. Issue notice returnable in 4 weeks, Mr.
And for 3, 4, 5, and 6.
I'm for one also. That's clear.
S. They appears for respondent number 1, and Mr. SCKL appears for respondent number 3 to 6.
Yeah, Lordship.
Mr.
I'm appearing for respondent number 2 on behalf of Mr. S.K. Mehta.
What is your name?
S.K. Mehta.
KK Medi appears on behalf of Mr. SK Medi, learned counsel for the respondent number 2. Then you make a Mr. The counsel for the party shall submit their affidavit within 4 weeks. This is the matter of the 4 weeks.
But still fix a date, madam.
First time, no hardly.
Permission item 2 to 53.
Yes, first of all, yes, 2 to 53, no? 52, I think. No? There is this item 52 out here. Now, item 52 is a Oil India matter, termination of service. It has nothing to do. I said, you're for that. So I'm sending it back. Let it be listed before the appropriate bench. Naturally, it has nothing to do with this issue.
I'm appearing in for responding in this matter.
This is a bench 3 matter.
Yes, that's true. That's true.
And this is termination of service, nothing to do with compassionate appointment.
Correct. I was therefore wondering why this matter has come here. Maybe on some special cause it has come here.
It is tagged along with all this.
I think we release that and let the appropriate. Oblige.
Give me a blank paper. Which writ petition should we look at? Do we need?
My lord,
Which writ petition number do we look at?
writ petition number,
Serial number?
my lord, the affidavit, the government has filed their affidavit in 5079.
5079.
And I'd like to.
Item number?
507, item number 1. Item number 5.
Item 5.
And I'll also, my lord, rely on my additional affidavit filed in item number 4.
Item 4.
My lord, there are about 60 cases in this series, my lord. And
All different facts.
all on my lord, the facts are a little different, but they can be grouped together under certain heads.
So under certain heads, yeah, different heads.
Yes, my lord. My lord, I have noted down, if your lordship, my lord, kindly takes note of this fact, my lord.
Yes.
Now, there are some cases which are not at all considered by the DLC or the SLC.
Yes.
That is the number one category.
Just a minute.
My lord, I am appearing in.
Yeah, have you made a list, small note? No.
In fact, my lord, I have made the list. I didn't get the time to type it out, my lord.
Okay, some cases not decided by
By
DLC.
DLC or SLC. Then, my lord, cases considered and recommended by the DLC, but the SLC consideration was pending as on the date of notification of the, my lord, that 18/9/2004 notification. DLC recommended, but SLC can consideration was pending. Then, my lord, the third category, my lord, there are some cases which are rejected by the SLC, but my lord, that rejection is, my lord, wrong. As
Whether is, but who said is wrong? The petitioner said is wrong.
petitioner says it is wrong. This is, my wrongly
so,
rejected by the DLC.
that's a different issue.
My lord.
That's a different issue.
But that is what I understand, my lord, these are the categories. Although, my lord, I do not represent-
SLC rejected,
no, my lord, DLC rejected.
but not challenged.
No, my lord, challenged, my lord.
But challenged.
But challenged.
But challenged in WPC.
Yes, my lord. Then that is, my lord, by DLC, rejection by DLC. There are some other cases, my lord, where cases have been recommended by the DLC, but the SLC has, my
Not
lord,
set. And not considered.
cancelled it, my lord. That is another category. And, my lord, there are cases where direction of the court
To consider.
either by the DLC or the SLC, but not considered. There is a direction from this honorable court, but, my lord, the consideration was not given by them, by the authorities. Then, my lord, cases where the petitioners did not approach the court earlier. Some, my lord, approached very late. They approached, my lord, just before the time. Before the, my lord, this notification was issued. Then cases where the applicants were minors at the time of date of the breadwinner.
Yes.
And the last category, my lord, I have categorized these applications for compassionate appointment which have been made just before the notification dated 1/4/2017. My lord, some persons died, my lord, just before this notification. They are also, my lord, a class by themselves. Now, my lord, so far as the challenge to the OM is dated, my lord, OM dated 18/9/2024. My lord, before that, your lordship may like to go through the, my lord, the office memorandum and notifications which were issued prior to it, my lord. I have prepared a bunch, my lord, for your lordship convenience. These are all on record. We have already provided your lordship.
This is the one.
This is, my lord, the first notification that we could lay hands on, my lord, on 9/9/1983.
Yes.
9/9/83, my lord. That is where, my lord, the compassionate appointment, perhaps, my lord, a scheme was prepared for the first time.
Yeah. I can't read. They should at least type it out. They've got such
No,
a
my lord,
bunch
in
of cases.
In fact, it will not be necessary to read because, my lord, this has all been superseded subsequently.
Okay, but then when you give something, please give a readable copy. Don't give, otherwise don't give me at all.
That's true, my lord.
It's like giving a beggar a torn 100 rupee note. He cannot do anything with it.
I'm
He'll
sorry,
just look
my
at it and cry.
because
The same with me. I'm looking at something, I'm crying because I can't read it.
I'm sorry, my lord, because of possible time we could not, my lord, get them of this type.
When you give something in good condition. Be,
And that has been superseded subsequently, my lord.
maybe.
1983 is the first notification. The second notification.
Unreadable. This, there are so many of you.
We have some readable,
My
little
lord,
bit readable.
I've got a better copy. I'm sorry, my lord.
Oh, you have got a better copy. Now you read your copy.
We have the whole bunch, lordship, all. in stick.
My learned friend is also given my.
This is, but you should have given me the same,
True, my lord.
similar.
In fact, I was trying to gather information from the other.
How you
petitioners.
return this? Take this back.
No, the other
The
documents.
torn note is returned.
No, my lord, the other documents, your lordship, may like to read.
Other documents are same, I think, same condition, I think, huh? But this, you should have given me same quality. What is this? You want me to decide your matter? You're giving me an unreadable copy. I cannot read it. My eyesight will, yes, yes,
Then,
then
my lord,
1983, then
my lord, 16/5/2012, there was my lord, another notification, but that was issued by the education department, elementary
16/5
education, laying down the minimum qualification required for compulsory appointment. That is dated, my lord, 16/5/2012.
that is not here.
In the other one, my lord, illegible branch file. 16/5/2012.
I should give better copy. What is this?
Now, your lordship may kindly come to the next, my lord, notification, next OM, my lord, at 1/6/2015, my lord. This your lordship may like to read.
No, you see, when you give, please give me this better copy 2012. In the meantime, you ask one of,
My
you have got, yeah, how many, 50 something cases, and not one of you all can give me a good copy. Not done, it's not
In
done.
fact, my lord, try to, huh? Sir? We'll get it typed, my lord. I try to consolidate all the cases, my lord, so that the time of this.
No, no, you see, it's not that. Since I am going into the issue, I have got to go from the very beginning, probably. At least I have got to read, maybe not in the order, maybe not have put down, but at least I have got to convince myself as to how everything flowed. How did it start from the beginning? The object, everything will be here. There'll be certain things, then you most probably will have to read into it those Achyut Ranjan Das and that Faziron Nisa also. But at least this should have been, this 2012, I'm quite sure that Faziron Nisa judgment or Achyut Ranjan Das, they might have been mentioned, I don't know. Unreadable. You try to read this, unreadable. Basic decency requires that you should give me a normal copy.
Provided, my lord, type.
Yeah, you should have. So, some courtesy should be shown to the court. Yes, then.
Then, my lord, the office memorandum dated 1st of June 2015. This your lordship may like to read, my lord.
Yes,
May I read it, my lord?
yes, yes.
Because by this, my lord, the earlier policy has been reviewed. And my lord, earlier notifications have been superseded. This is a notification by the personnel department.
Yes.
I'll read the relevant part, my lord. The first paragraph. At present, appointment on compassionate ground of the dependents of state government employees who die in harness or retire prematurely on being declared permanently incapacitated for service is governed by the provisions laid down in various OMs and government notification issued from time to time, such as, my lord, the notification dates have been given, my lord. All the notifications have been referred to. Thereafter, your lordship will find the
So if the notice, you have not given me the 1990
my
notification.
lord, this, my lord, we could not lay our hands on. Maybe, my lord, in the banks given by the learned advocate.
Neither the 92 notification. Okay, then 96 notification, 97 notification, 2000 notification, 2009 notification. None of them are here. Okay, then.
The government have since some time past been considering the necessity of reviewing the provisions contained in the above quoted OMs, orders, etc. After careful revision of the matter, the government of Assam is now pleased to supersede all the earlier office memorandums, notifications, along with corrigenda and or orders issued in the context of the said OMs and lay down the following principles and procedure to be followed while dealing with the issue of compassionate appointment to the dependents of government servants who either die in harness or retire prematurely or being permanently incapacitated, as declared by a certificate issued by state level standing medical board, and received invalid pension under the provisions of Rule 82 of the Assam Service Pension Rules. Number 3, missing and whose whereabout is not known for at least 7 years. These principles will be applicable to recruitment in all state government establishments with immediate effect. Then, my lord, what does the government servant mean? These are, my lord, notified. Your lordship may skip this, my lord. I'd like to take your lordship to the principles that have been, my lord, laid down. The principles your lordship will find at page 4
4 of what?
of this page, my lord. This is the first page, 4th page. Your lordship may come to the 4th page. The pagination is at the bottom. There have been, my lord, as many as 24 perhaps, my lord, principles have been laid down. I'll, my lord, refer to certain principles only, my lord. The others may not be relevant for the purpose of determination of the, my lord, issue that was for consideration before your lordship. Principle 1. All pending applications against existing vacancies as per the quota are marked, including the cases of the petitioners in the present cases and all others who may not be before the court, shall be decided in accordance with the proposed directions to be laid down in the present order and also in accordance with the principles noted in the preceding paragraph of this order. This will be done within a period of 4 months from today. The present direction naturally has to be considered as a one-time measure in view of the subsequent directions as laid down in the succeeding paragraphs. My lord, my lord, word I'd like to stress here, my lord. The persons who are not before the court, their cases are also to be considered. It's not that, my lord, everyone has to, my lord, come to the court. Why I am submitting this, my lord, I'll explain it later on. Then your lordship may come to principle 4.
So you're saying under principle 1, all persons.
Yes. A duty is cast on the, my lord, government that you have to consider each and everyone who, my lord, falls within these parameters. As a model employer, my lord, it is their bonding duty. Then, my lord, that clause your lordship will read with principle 4.
Yes.
Principle 4 says, my lord, the district level committee will meet once every 2 months on the last Saturday of the second month. They have, my lord, already fixed that, my lord. Every 2 months, the district level committee has to sit. Then, my lord, principle 8 says the state level committee will meet once every 3 months. They have themselves, my lord, fixed this, my lord, time schedule for holding the DLC meeting and SLC meeting. Principle 9, all the vacancies available against the quota of compassionate appointment must be filled up within a period of 6 months from the date of occurrence of the vacancy in accordance with the present directions. Then your lordship, my lord, skip the other principles and come to the last one at, my lord, running page 7, 24A. 24 small e.
Yes.
As regards the pending cases, prior to issuance of the direction in Ochut Ranjan Das and 162 others versus State of Assam, that is 3rd August 2006, the authorities, departments need to ensure the compliance of the directions contained in Principle 1 urgently. The High Court has fixed 30th September 2010, within which all such pending cases were required to be considered. Those departments which have not yet complied with the Principle 1 and disposed of all such pending cases shall complete it within 6 months from the date of issue of this OM. Judgment kita kumita pieces as page paragraph. So that was in my lord on 1st of June 2025. Then my lord, the notification dated 14 September 2017 came. Scheme for compassionate family pension in lieu of compassionate appointment, in short called the compassionate family pension scheme. My lord, the question failed from your lordship, my lord, why we have not challenged this notification. So we have not, my lord, to my knowledge, my lord, in none of the cases this has been challenged. And why it is not challenged, my lord, I'll explain. Before that, my lord, I'll read some paragraphs. Governor of Assam is pleased to notify the following guidelines for a new scheme, namely the scheme for compassionate family pension in lieu of compassionate appointment, in pursuance of paragraph 61 to 63 of the budget announcement of 2017-18, and in complete supersession of the compassionate appointment policy of the state government, notified by the Personnel B Department, wide number such and such, dated 1st June 2015, and all other related OMs. So, my lord, purportedly, by this paragraph, the new scheme, family pension scheme, supersedes the compassionate appointment policy that has been laid down on 1st of June 2015 and all other related OMs. Now, your lordship may kindly come to the next page. Clause 5.11. The scheme is applicable to those employees who die in harness on or after 1/4/2017. However, the relevant OMs related to compassionate appointment will be applicable to those who died on or before 31/3/2017. So, my lord, in the first paragraph, they say all the my lord OMs and notifications are superseded. But in 5.11, they say that the cutoff date has been stated 1/4/2017. The scheme will be applicable to those employees who die in hardness on or after 1/4/2017.
So it is implied that it will be superseded. Those OM will be superseded for cases that arise out of from 1/4/2017.
17. So 1/4/2017, new scheme has come. But so far as my lord, the person
Earlier, persons
have died.
persons who applied prior to 1/4/2017, they will be covered by the earlier OM.
Right. And that's the reason, my lord, this has not been challenged because, my lord, all the petitions before your lordship, they are, my lord, breadwinners died prior to 1/4/2007. Therefore, there was no necessity of, my lord, challenging this. But this makes it clear that even though, my lord, 2015 notification OM has been said to be, my lord, superseded, but that remains for the persons who died prior to that date. Now, my lord, office memorandum dated 18/9/2024, which is under challenge. After this, my lord, 2017 notification was issued and it was made clear that there is a cutoff date 1/4/2017, after which anybody dying, my lord, they will not be given the compassionate appointment on the previous office memorandum, but they will be governed by 2017 notification. There was, my lord, no necessity of issuing this order, which has, my lord, made this situation clumsy, and that's why, my lord, the petitioners are before your lordship. Now, your lordship, I'll read it partly, because your lordship has already read.
No, no, I've not read.
Then, my lord, I'll read in entirety, my lord.
This is also again bad copy. How come the notification that you want to set aside,
Better copy, yes, type.
you're giving this code a bad copy.
Better copy.
My God.
In the affidavit of the government, my lord, they have annexed, I think that is better, my lord.
It should tell you, you've got so many writ petitioners. Basic decency should be shown to the court. How many times do I have to tell you, you are a senior counsel? Yes, read. What to do?
Subject, review of the schemes for appointment of a family member of a government servant on compassionate ground. The government of Assam, in the finance department, in complete supersession of the compassionate appointment policy notified by personnel B department by OM dated 1/6/2015 and other related personnel departments OMs issued notification for compassionate family pension scheme in lieu of compassionate appointment, white notification number such and such dated 14/9/2017, on the condition that this scheme is applicable to those employees who die in harness on or after 1/4/2017, and the personnel department's OM related to compassionate appointment would be applicable to only those who died on or before 31/3/2017. While considering the appointment on the scheme of compassionate appointment, the appointing authority is required to keep in mind that the concept of compassionate appointment is limited to the need for immediate assistance. If several years have passed after the date of a government servant, it would appear on the fact of it that the family has managed to support itself all these years and has some means of subsistence. In such a case, compassionate appointment would not entirely be justified. Compassionate appointment is not a matter of right, and the same was envisaged from the policy from the point of view of immediate unexpected hardship faced by the distressed family and the need for assistance to such family having regard to the compelling financial circumstances, if any, of the deceased dependents at the time of death of the sole breadwinner. Compassionate appointment cannot be claimed of or offered after lapse of a considerable time and after the crisis is over. Such a delayed appointment would also amount to treating a claim of a compassionate appointment as though it were a matter of inheritance based on the line of succession. Appointment on compassionate ground should not be a source of recruitment, but a means for the family to tide over the sudden financial distress. The Honorable Supreme Court also, in a number of cases, has held that granting compassionate appointment after a lapse of considerable time after the date of a government employee would not be in furtherance of the object of a scheme of compassionate appointment. In the judgment dated 3/3/2023 passed by the Honorable Supreme Court in civil appointment number such and such in the case of State of West Bengal versus Debobrat Tiwari and others, the Honorable Apex Court has observed that the application for appointment on compassionate grounds shall have no redeeming purpose to be considered and decided several years after they were filed. In this connection, para 7.5 of the aforesaid judgment dated 3/3/2023 is reproduced herein as below. 7.5. Considering the second question referred to above, in the first instance regarding whether applications for compassionate appointment could be considered after a delay of several years, we are of the view that in a case where the reason for prolonged delay, either on the part of the applicant in claiming compassionate appointment or the authorities in deciding such claim, the sense of immediacy is diluted and lost. Further, the financial circumstances of the family of the deceased may have changed for the better since the time of the death of the government employee. In such circumstances, courts or other relevant authorities are to be guided by the fact that for such prolonged period of delay, the family of the deceased was able to sustain themselves, most probably by availing gainful employment from some other source. Granting compassionate appointment in such a case as noticed by this court in Hakim Singh would amount to treating a claim for compassionate appointment as though it were a matter of inheritance based on a line of succession which is contrary to the Constitution. Since compassionate appointment is not a vested right and the same is relative to the financial condition and hardship faced by the dependents of the deceased government employee as a consequence of his death, a claim for compassionate appointment may not be entertained after lapse of a considerable period of time since the date of the government employee. In view of the circumstances mentioned above, it has been decided that no cases for compassionate appointment on compassionate ground to the family members of the state government employee who died in harness or retired prematurely on being declared permanently incapacitated for service or missing, or whose whereabouts is not known prior to 31/3/2017 shall be entertained by any administrative department authority for any reason whatsoever be placed before the SLCs or DLCs for recommendation of candidates for appointment on compassionate ground. The cases of employees who died in harness after 31/3/2017 have been taken care of by compassionate family pension scheme in lieu of compassionate appointment by number 14/9/2017. Now, Your Lordship finds that in the second paragraph, certain observations has been made for reviewing, and it is said that the Supreme Court has also said, and my lord quoted paragraph 7.5 of Tiwari's judgment, Debabatu Tiwari's judgment, but then my lord paragraph 2 and my lord paragraph 7.5 are pari materia. That is the only ground, the ground based on which this OM is issued, my lord, the judgment in Debabatu Tiwari's case.
So the compassionate family pension scheme is still there.
Yes, my lord.
So this OM bars what? This OM bars the consideration of a compassionate appointment.
In spite of
prior to 1st April 2017.
My lord. Because, my lord, by the earlier notification of 2017, it was made clear that, my lord, after 31st, my lord, March 2017, that will be considered by the
1st April 2017 onwards, they are all going to get compassionate family pension.
yes,
Correct?
yes.
Now, prior to March 2017, and between the issuance of this OM, how many years had passed? 7 years.
2 years. 2015 was the OM, my lord, last OM.
No, then 2017 OM.
2017.
2017 OM and 2024 OM.
Yes.
There is a difference of 7 years.
7 years.
So 7 years have passed, so, now all those claims that are made are all 7 years or older.
Yes.
Now, what is the object of a compassion appointment?
My lord, before coming to that, my lord. 2015 OM was very clear, my lord, the policy was taken. The duty was cast on themselves, my lord, by them, relying on Uchut Chandra Das. That the DLC has to sit every 2 months, the SLC has to sit every 3 months.
Okay, suppose, okay, now that aspect will cover only one portion of the batch of writ petition for those which have not been considered. But what about those cases where the DLC has sat?
Where, my lord, as I have, my lord, tried to classify the groups of cases, there are some cases where, my lord, DLC has recommended and the, my lord, SLC was yet to recommend. They were. my lord,
That is one. What about cases where the DLC has rejected
and
or
my
the
lord,
SLC has rejected?
rejected and challenge has been made before this
And,
honorable court.
okay, and what about cases where no challenge has been, where challenge has been made, but challenge has not been disposed of? You see, because at the end of the day, again, we'll have to see the object of the compassion appointment. What is the object?
I get your lordship, my lord. But the question here is, my lord, you frame yourself a policy. You decide that those cases which are pending prior to 2015, those are to be decided in 6 months. You do not do anything on that. And because of that, my lord, can our rights for consideration be taken away?
But all your cases have been considered.
No, not all, my lord.
Who has not, whose cases has not been considered?
My lord, there are many cases which are
There are many cases which are not considered.
not considered.
Consider one authority for the DLC is considered, SLC is not considered. And there are directions for consideration.
And what about, okay, now that is with regard to various aspects. What about those cases where the person died in 95 or something like that?
I'll come to that, my lord. That's why, my lord, whether the particular paragraph that has been quoted, which is the basis of the, my lord, impugned OM, my lord, whether, my lord, that has really laid down a law.
Really?
It has laid down a law. Because the other day I submitted, my lord, whether this is a, my lord,
Yes, so we'll have to see whether this is actually is taking over the functions of the DLC or the SLC as to how it should be considered. Or whether can it be said that it is in furtherance of the scheme? Is that
My lord,
is that what you're trying to project?
my lord, one of my submissions is that, my lord, you have delayed the, my lord, entire consideration, and you say that so many years have passed by. Whereas, my lord, the duty was cast on you, you yourself said, reiterated, the court has directed in Uchut Chandra Das, and thereafter you have fixed 6 months' time, but you did not consider. You kept it pending. And the, my lord, applicants are not responsible for that. Can that, my lord, take away their right? It was delay on the part of the, my lord, the applicants.
Okay, what about delay on the part of the applicants? Delay on the part of the government, you have said.
Yes,
Okay, they did not consider. What about delay on the part of the
Delay
applicants?
on the part of the, my lord, applicants, my lord, if it is delayed beyond 1 year, those are rejected, my lord.
Those are rejected.
Those are rejected. And they are
No,
not before your lordship, my lord.
no, they are.
Some may be, my lord.
There are. There are cases where they have died in 95 and all. That's why I've said. That's why I'm giving that.
My lord. Yes, there are cases.
95. And now 2025. 30 years have passed. Probably that time he was a minor. Now he must be having 5 kids or something like that.
My lord,
With his compassion appointment application.
there is one instance, my lord, the wife applied. The wife did not get it. Then after some years, my lord, the son.
And there's another aspect. Can the parents claim for the children? There are some instances where the surviving spouse has made an application on behalf of the child. Can that be done?
My lord, there is another one aspect, my lord, the son is a minor. Naturally, my lord, natural guardian can file the application on behalf of
For the child.
for the child.
And the child is say 8 years old, 9 years old. So they'll have to then they'll consider after 9 years. Is
lord.
that the purpose of the thing? Or why can't the mother or
First thing is, my lord, the wife has to claim appointment, my lord, if
correct.
eligible.
If now can that is why one question arises. Can a mother claim for a minor child who is around 8, 9 years old?
Ideally not, my lord. But then, my lord, this question has been dealt with by the Supreme Court. I'll place that decision. My lord, when there is a minor and the wife applies, wife does not get it, then my lord,
No, if the wife doesn't apply, there are cases here where the wife hasn't applied at all. Applied only for the thing, for the child.
the minor cannot be appointed naturally, my lord. Therefore, the
Actually,
minor,
so now what is the object of asking for a consideration of the minor's application
when he becomes
after
major.
9 years or 8 years or 7 years or 6 years? The very object of compassionate appointment is defeated.
In fact, my lord, that particular family, the family's position is very piquant, my lord. Very piquant. The purpose is to, my lord, give redress to the, my lord, the suffering family.
Correct.
Wife is not entitled to get appointment.
No, sometimes the wife doesn't apply. There's no reason given why the wife has not applied.
My lord, most of these people are from the, my lord, very low strata
But
of
then
the society.
low strata, but
They
then no, I can understand you're trying to say they're ignorant. But if they had the brains to apply for the child, why not apply for themselves?
No, my lord, my answer to that would be maybe, because this is a hypothetical situation again, my lord, maybe
No, there are cases there among the list.
my lord, if the wife is illiterate, she cannot apply for a grateful job also, my lord.
And this minor boy is not even class 8, class 7.
Yes, my
Well,
lord.
then how can you apply now and say that he has to be considered when he becomes a major?
By the time, my
Can
lord,
that be allowed?
my lord, by the time he attains the majority, he acquires the, my lord,
But then the very object of that the compassion appointment to mitigate the immediate suffering has gone. The
My
crisis is past.
in fact,
He has survived. He's become a grown
in
man.
this type of situation, my lord, the suffering continues.
How do you know?
Suffering continues because, my lord, there is no one who can be appointed. That is, in fact, that is the reason why, my lord, this scheme, family pension scheme has been, we do not have any objection to that scheme, my lord. Family pension scheme is, my lord, perhaps better than, my lord, the earlier, my lord, office memorandum. If, my lord, no one is eligible,
Compassionate family pension scheme.
maybe, my lord, that's a better option.
No, it's a better option, no doubt.
Because this type of situation should be
Because then there is everyone gets it.
then everyone gets, my lord, gets it irrespective of whether, my lord, the wife is eligible or not, illiterate or not, my lord, there is a minor only. Those family will get the, my lord, succor. But then, my lord, here these persons, my lord, all the petitioners before your lordship, my lord, their breadwinners died prior to that, my lord, 2017, and therefore, my lord, whether they are entitled to be considered under the 2015 notification or not, that is the issue, my lord. Which has been, my lord, denied by the, my lord.
Okay, let us see the principles once again in the 2015. 2015, yes.
The principles start at page 4 of the notification dated 1st of June 2015.
Page 28. Okay. All pending applications against existing vehicles as per the quota earmarked shall be decided in accordance with the proposed directions to be laid down. So principle 10 is also laid down that after 2 years, it'll have to be understood to have spent its force.
If there is no vacancy, for want of vacancy,
Yes.
that is a different situation. Because my lord, non-consideration and non-availability of vacancy are two different things. And in fact, my lord, the scheme that has been, my lord, prepared, that requires that, my lord, the DLC will, my lord, assess the, my lord, factual situation regarding whether they need this succor or not, my lord. There is a factual determination part. If in the meantime, my lord, someone in the family has been appointed, taking a government job, my lord, his case will be rejected. Those factual determinations are made by the, my lord, the district level committee. After that only, my lord, they recommend it to state level committee. So factual determination is a part, my lord. Whether they are still, my lord, suffering, whether, my lord, they have
Anything else? That's all.
So far as the notifications are concerned, my lord, and this is it. And my lord, I'd like to rely on some, my lord, case laws. Firstly, my lord, on the question whether the basis of the impugned notification, relying on one paragraph of Obiter's judgment of the Honorable Supreme Court, he lays down the law. Yeah, understood, yeah. They have quoted 6.5.
7.5.
Under Article 141, doesn't it lay down the law?
My lord, under Article 141, my lord, whatever the Honorable Supreme Court, my lord, in a judgment it passed, my lord, there are two parts to it, my lord. Whether, my lord, it is a decidendi, whether it can be taken as a precedent, and, my lord, whether these are obiter. On that, my lord, I'll place some case. But before that, my lord, I'd like to read one paragraph of Obiter's judgment. One paragraph, my lord, the government has relied, paragraph 7.5, which has been quoted in the office memorandum itself, 7.5. Now, my lord, I have given a bunch of the case laws, my lord. If your lordship may have got it, my lord.
Yes.
Now, your lordship will, if your lordship has taken my bunch, because, my lord, I have got the printout from Supreme today, not from SCC. These are more bunch.
You read?
Yes. There, your lordship may kindly read paragraph 11.
I thought you wanted 7.5.
7.5 is the, my lord, that I have already read, my lord, that has been quoted in the impugned office memorandum.
Yes.
Paragraph 11 to be said. Paragraph 11, your lordship will find that page 11,
Yes.
last sentence, my lord. It may be apposite at this juncture, has your lordship got?
Yes, yes.
It may be apposite at this juncture to refer to the following observations of the court in Malayananda City versus State of Odisha, year 2022, SC 2863, as to the manner in which the authorities must consider and decide applications for appointment on compassionate grounds. 9. Before parting with the present order, we are constrained to observe that considering the object and purpose of appointment on compassionate ground, that is, a family of a deceased employee may be placed in a position of financial hardship upon the untimely death of the employee while in service, and the basis or policy is immediacy in rendering financial assistance to the family of the deceased consequent upon his untimely death. The authorities must consider and decide such applications for appointment on compassionate grounds as per the policy prevalent at the earliest, but not beyond a period of 6 months from the date of submission of such complete application. We are constrained to direct as above, as we have found that in several cases, applications for appointment on compassionate ground are not attended in time and are kept pending for years together. As a result, the applicants in several cases have to approach the concerned High Court seeking a writ of Mandamus for the consideration of their applications. Even after such a direction is issued, frivolous or vexatious reasons are given for rejecting the applications. Once again, the applicants have to challenge the order of rejection before the High Court, which leads to pendency of litigation and passage of time, leaving the family of the employee who died in harness in the lurch and in financial difficulty. Further, for reasons best known to the authorities and on irrelevant consideration, the applications made for compassionate appointment are rejected after several years or are not considered at all, as in the instant case. If the object and purpose of appointment on compassionate ground as envisaged under the relevant policies or the rules have to be achieved, then it is just and necessary that such applications are considered well in time and not in a tardy way. We have come across cases where for nearly 2 decades, the controversy regarding the applications made for compassionate appointment is not resolved. This consequently leads to the frustration of the very policy of granting compassionate appointment on the date of the employee while in service. We have therefore directed such applications must be considered at the earliest point of time. The consideration must be fair, reasonable, and based on relevant consideration. The application cannot be rejected on the basis of frivolous and for reasons extraneous to the facts of the case. Then and then only the object and purpose of appointment on compassionate ground can be achieved. In the said case, the claim of the appellant applicant therein for compassionate appointment was directed by this court to be considered by the competent authority. This court noted that in the said case, there was no lapse on the part of the appellant applicant therein in diligently pursuing the matter. The delay in considering the application of the appellant therein was held to be solely attributable to the authorities of the state, and no part of it was occasioned by the appellant applicant. Further, in the said case, the appellant applicant was prejudiced not only because the prolonged delay in considering the application, but also by the fact that in the interim, the policy of the state governing compassionate appointment has changed to his detriment. Therefore, the fact that the said cases were distinct from the facts involved herein, in the present case, the conduct of the respondent writ petitioners cannot be said to be blameless, in that they did not pursue their matter with sufficient diligence. However, the observations made in the said case as to the manner in which the application for compassionate appointment are to be considered and disposed of are relevant to the present case. So, my lord, this is what has been, my lord, observed after, my lord, quoting the Malayananda Setti's case. Then, my lord, your lordship may also read, my lord, paragraph 14. However, we must sound a strong word of reproach, directing the authorities of the appellant state about the manner in which the applications for compassionate appointment of hundreds of dependents have been dealt with. Much uncertainty looms around the scope, extent, and beneficiaries of the various schemes formulated by the state government governing the compassionate appointment, and therefore the concerned authorities are unwilling to positively decide claims for compassionate appointment. This may have ultimately resulted in prejudice to the families of many government employees dying in harness. Delay on the part of the authorities of the state to decide claims for compassionate appointment would no doubt frustrate the very object of the scheme of compassionate appointment. Government officials are to act with a sense of utmost proactiveness, and immediacy while deciding the claim of the compulsory appointment so as to ensure that the wholesome object of such a scheme is fulfilled. The question as to whether a direction issued several years after an application for compulsory appointment to consider and decide the said application is in consonance with the object of a policy scheme for compulsory appointment has been answered in the negative. However, we shall also examine whether these appeals must succeed on a second count, that is, whether there exists any.
So the
scheme-
first part of para 15 is not in your favor.
My- That's why I have read, my lord, the complete, what I am on is that, my lord, this case was decided by the Honorable Supreme Court on certain facts. And what are the facts? There was no scheme at all in the state of West Bengal. But here, my lord, in Assam, we have a, my lord, clear-cut scheme and policy, man. And there are directions of this Honorable Court to follow it. And pursuant to that, my lord, the principles have been laid down as to how they have to proceed. Therefore, my lord, this observation in paragraph 7.5 is not a, my lord, ratio decidendi. And in fact, my lord, this decision has been discussed in, my lord, two judgments of, my lord, one Calcutta High Court and Madras High Court, my lord, where, my lord, they have distinguished on facts. If your lordship permits, my lord, I'll place those decisions. That will be my precise argument, my lord. What has been decided by the division bench in those two, my lord, High Court cases. One is at, my lord, after this judgment in this bunch. But then, my lord, before that, perhaps your lordship may like to read the Malayananda Setti's case, the next case in this bunch, which is, my lord, partly quoted in Debabrata Tewari's case. I'll not read the entire, my lord, only relevant paragraph. Paragraph 8 will be relevant. Paragraph 8 and 9. May I read it, my lord? Malayananda Sikh versus State of Odisha. Here is a case, my lord, where the person died in 2010 and the direction was issued in, my lord, 2020. 22, my lord, I'm sorry. Paragraph 8. In view of the above discussion and for the reasons stated above, the impugned judgment and order passed by the High Court is hereby quashed and set aside. The respondents are directed to consider the case of the appellant for appointment on compassionate ground under the 1990 rules as per his original application made in July 2010. And if he is otherwise found eligible to appoint him on the post of junior clerk, the aforesaid exercise shall be completed within a period of 4 weeks from today. However, it is observed that the appellant shall be entitled to all the benefits from the date of his appointment only. Then paragraph 9. Before parting with the present order, we are constrained to observe that, considering the object and purpose of appointment on compassionate ground, that is, a family of the deceased employee may be placed in a position of financial hardship upon the untimely date of the employee while in service, and the basis or policy is immediacy in rendering the financial assistance to the family of the deceased consequent upon his untimely date. The authorities must consider and decide such applications for appointment on compassionate ground as per the policy prevalent at the earliest, but not beyond a period of 6 months from the date of submission of such completed application. We are constrained to direct as above, as we have found that in several cases, applications for appointment on compassionate grounds are not attended in time and are kept pending for years together. As a result, the applicants in several cases have to approach the concerned High Court seeking a writ of Mandamus for the consideration of their application. Even after such a direction is issued, frivolous or vexatious reasons are given for rejecting the application. Once again, the applicants have to challenge the order of rejection before the High Court, which leads to pendency of litigation and passage of time, leaving the family of the employee who died in harness in the large and in financial difficulty. Further, for reasons best known to the authorities and on irrelevant considerations, applications made for compassionate appointment are rejected after several years or are not considered at all. as in the instant case. If the object and purpose of appointment on compassionate ground as envisaged under the relevant policies or the rules have to be achieved, then it is just and necessary that such applications are considered well in time and not in a tardy way. We have come across cases where for nearly 2 decades, the controversy regarding the application made for compassionate appointment is not resolved. This consequently leads to frustration of the very policy of granting compassionate appointment on the date of the employee while in service. We have therefore directed that such applications must be considered at an earliest point of time. The consideration must be fair, reasonable, and based on relevant consideration. The application cannot be rejected on the basis of frivolous and for reasons extraneous to the facts of the case. Then and then only the object and purpose of appointment on compassionate grounds can be achieved. In fact, my lord, non-consideration for a prolonged period of time, that also, my lord, in effect, my lord, results in a, my lord, deemed rejection. Now, my lord, the Calcutta Division Judgment, if your lordship permits me, I'll my lord, read this, my lord, 3 paragraphs only, my lord. Airports Authority of India versus Prabhas Desai.
22, 24.
Paragraph 22. Because, my lord, in this case, also in the my lord, Rajasthan case, in this case, and also in the my lord, Rajasthan High Court case of the Division Bench, my lord, elaborately, my lord, this my lord, Debabrata Tiwari's case has been discussed and distinguished. Paragraph 22, my lord, may I read?
Yeah.
On consideration of submissions made on behalf of the parties and the facts summarized, it is clear that the father of the writ petitioner number 1 was a Group D staff and he was working as Safai Wala. The economic, social, and academic background of the deceased person and his family members need to be appreciated. The wife of the deceased and the writ petitioner number 1 are not aware or well versed with the legal niceties and nuances and may not have the wherewithal to pursue the luxurious litigation. The petitioners are like a man in the street, alienated against the law, being confounded and baffled with its complexities, with no comprehension about it or the legal system by which he is governed. The writ petitioner number 1 was barely 20 years old when his father died. He studied up to class 8. The widow was illiterate. The father of the writ petitioner number 1 admittedly was the only breadwinner. They were struggling for survival. A death in the family comes as a rude shock, and the entitlement to the service and other benefits are required to be ensured by the employer in order to enable the family to tide over the financial difficulties likely to be faced by the reason of such untimely death. It includes consideration of a request for compassionate appointment and to consider such prayer in accordance with the existing scheme. They would always be dependent upon the employer for guidance and would expect the employer to behave responsibly. AAI, that is Airports Authority of India, is an authority under Article 12 of the Constitution of India and is obliged to and expected to behave like a model employer. AAI is expected to act in a bona fide and reasonable manner. AI does not dispute that the wife of the writ petitioner had filed an application for compassionate appointment on 19 March 2007, although AI claimed to have rejected the said application on 3rd July 2008. However, no such decision appears to have been communicated to the widow. In fact, the subsequent correspondence between the parties would not show that any final decision was taken on the said application. It was only before the learned single judge on the basis of a chart. It was contended that in terms of the then existing scheme, 60% weightage was required, whereas the petitioner got 45 marks out of 100, And in justification of awarding 45 marks, reliance was placed on the petitioner's own declaration regarding his house details. If AI has applied the wrong yardstick for the purpose of assessing the suitability of the writ petitioner number 1 for the said post and thereby made him ineligible during the period when the scheme was in force, it cannot be heard to contend that the claim is bound to fail due to delay and laches on the subsequent discontinuance of such scheme. It cannot deny its responsibility in not considering the application for compassionate appointment provided all other criteria are fulfilled. Once a dependent fulfills the criterion, the employer is duty bound to give employment. It is also the
No,
duty.
no, what do you want to show me here?
My lord,
What do you want to show me?
my lord, I have my lord detailed the facts. Thereafter, your lordship may come to my lord paragraph 24, because my lord, the court has observed, my lord, they are the people on the street. They are not, my lord, used to the niceties of the my lord law.
So,
Then paragraph 24. Now theory
But
has been given.
all the people who have come here are all represented by very well-known lawyers,
My lord,
including the one that is standing right
I
now.
believe, my lord, most of them, including myself, my lord, we are doing it pro bono, my lord.
Anyway, it doesn't matter. Yeah.
That's fine.
But what do you want to say? Otherwise, they're just reading out.
No, my lord, I have given the facts. Now, my lord, the double protective case has been discussed.
Okay,
Paragraph 24.
paragraph 24.
Right.
Yes.
Mr. Dhar, senior advocate, has strongly relied upon the Deborah theory, paragraph 35, to demonstrate that in a case where, for reasons, prolonged delay either on the part of the applicant in claiming compassionate appointment or the authorities in deciding such claim, the sense of immediacy is diluted and lost. The effect of delay is stated under. Paragraph 35, my lord, I have already read, my lord. I'll not read that. Then, my lord, your lordship may kindly come to paragraph 25. We have read the judgment carefully, and we are of the opinion that the said judgment is distinguishable on facts. Paragraph 25.
Yes.
We have read the judgment carefully. We are of the opinion that the said judgment is distinguishable on facts. As would appear from Debabutu Tewari, the heirs of the employees of Burduan, Ranaghat, and Habra municipalities have applied for compassionate appointment to the post in the concerned municipality under Dine Harness category. In fact, it appears that the chairman of Burduan municipality, after causing an inspection, forwarded an approved list to the director of local bodies, Government of West Bengal, for approval of appointment on compassionate ground, like here, my lord, in DLC. The director of local bodies, Government of West Bengal, did not take any step whereby a writ petition was filed. Petition was disposed of by directing the local bodies to take a decision on the recommendation of the chairman of the municipality within a period of 10 weeks. In continuation of the direction of the Honorable Supreme Court, the Government of West Bengal passed an order dated 16 October 2015, wherein it was stated that the director of local bodies had no authority to appoint on compassionate ground in urban local bodies unless the policy in the matter was laid down by the state government. It was therefore observed by the director of local bodies that as soon as the state government extends such policy for appointment of the employees of urban and local bodies under compassionate ground in die in hurdles category, the prayer of the writ petitioner cannot be considered. So, my lord, this shows that, my lord, there was no scheme. Then your lordship may kindly come to paragraph 32. Here, my lord, the Devoputra Tevaris, paragraph 47 has been relied, my lord. Strong reproach. Paragraph 32. On the facts, it was held that the sense of immediacy is diluted and lost in the present case. The Honorable Supreme Court used a strong word of reproach in keeping the application pending. In paragraph 47, it is stated, my lord, that I have already read the, my lord, reproach that has been made. Then, my lord, paragraph 34. The aforesaid judgment is distinguishable on facts. In the instant case, the application was filed when the scheme was in existence. The authorities communicated its reason for rejection. On the contrary, until the writ petition was filed in its communication, AAI has never contended that the writ petitioner number 1 is ineligible. It was only before the learned single judge and now before the bench, a faint attempt was made to show that the writ petitioner number 1 was ineligible. AAI had applied wrong criterion to hold the writ petitioner number 1 ineligible. It is right law that a judgment is not to be read like a statute, nor as a Euclid's theorem. The judgments are to be read, understood, and applied contextually. Then, my lord, 45 and 46, I'll read, my lord. It's a very long judgment. 43. Paragraph 43 will also be relevant, my lord. 43, 45. 43, I am reading, my lord. The judiciary is respected not on account of its power to legalize injustice, but because it is capable of doing justice and it is expected to do so. See collector, land acquisition versus so-and-so. Even otherwise, constitutional courts are duty bound to dispense justice in deserving cases without being desultory with the technical objection, as technicalities are always to step down and substantive justice must prevail. This tends to defeat a legal right of a litigant by inviting attention to the many lapses in the procedure adopted by the writ petitioner and lack of promptitude on the litigant. Incidentally, in this case, widow and son of the sweeper, in espousing the cause and expecting the constitutional courts to give importance to such factors, overlooking the many glaring faults and breaches of their statutory duties, if accepted, would give premium to an inexcusable conduct of the employer. It would in effect mean and signify, to borrow the expression from the pleasure of philosophy by Will Durant, of the proclamation by Theresimasus of Plato's Republic, that the unjust is lord over the truly simple and just, and the just is always loser by comparison. The purpose of the scheme was to rescue the family from mental, physical, and emotional and financial distress, and to improve the human living condition of the family, and this gets defeated due to manifest unjust conduct of the AAI. Instead of emotional and financial support to hand-holding, AAI was a denial one. Then 44, the scheme of compassionate appointment is a social beneficial scheme introduced and can be seen as a force of circumstances that tends to destroy equity that the force of legislation must always tend to maintain. It is a principle espoused by Rousseau and recognized in our Constitution to advance social justice. As succinctly put by the Honorable Justice A.M. Shela, former Judge, Supreme Court of India, to discriminate positively in favor of the weak, many sometimes be promotion of genuine equality. The writ petitioners approached the authorities in time. It was a manifest arbitrary act of the employer in denying employment. The writ petitioners have been denied a decent livelihood, and a timely action would have put the family in a better position. The contention that the writ petitioner number one is presently working as a contractual employee in the airport under a contractor, apart from being substantiated, is no consolation, and if it is accepted, it would only embolden an employer to act unfairly. Then your lordship may skip my lord and read.
There is one thing out, it says writ petitioners approach the authorities on time. I've always noticed this everywhere.
Yes, my lord.
Approach on time.
On time.
On time would be how much? What would be the reasonable time?
1 year, my lord.
1 year.
1 year has been laid down by the in the scheme.
So if they have come beyond 1 year, then there will be a problem.
That will be a problem. Then 46, my lord. One could not.
So just a minute, just let me write that down. 1 year time.
Then But our court has held that, my lord, that 1 year is also directory, my lord, not mandatory.
Okay, but okay,
But
okay,
then, Malad,
directly, but 1 year, okay, stretch it to how much? How many years can you stretch it to?
For application, for filing the application.
You,
Let us
you give me a reasonable time, you see, because we cannot now, since you are saying, okay, it's directory, that directory will be for how much can it be stretched to? Can it be stretched to 10 years, that 1 year?
No, my lord.
Would it be proper to stretch a 1 year period into 10 years?
Certainly not, my lord.
Certainly not.
And that's why, my
So,
lord,
will it be around at least another 1 year or so?
maybe, my lord,
Maybe.
But my lord, there is.
But it will not be 5 years.
It cannot be, my
It
lord.
cannot be 5 years.
And my lord, the factual assessment the DLC is supposed to do, my lord.
Huh?
The DLC is supposed to do, my lord, the factual assessment of the condition of the family. If, my lord,
No. Factual assessment, you see, factual assessment, so they have to do, that's a different issue. I am on the issue of when is the application for compassionate appointment generally to be filed? Within the 1 year, which
Within
is
1 year.
directory, you said?
as
Now,
per the scheme, my lord, it is 1 year.
within 1 year. So at best, maybe, okay, a few months here and there, they can
Yes,
delay.
my lord, if on, my lord, the factual assessment, it is found that they really, my lord, the family is suffering, they may, my lord, extend it.
They can be suffering after 30 years also. Then what happens? Supposing they don't find. But 30 years later, they find that they are still in the same boat as they were when he died. Then,
Those are perhaps not the cases here, my.
no, because there is a case of 95, I told you.
One case is there.
Yes.
95, but they applied on time.
No.
Individual facts, perhaps, my lord.
That is what, that is no big, but you see, since we are going to pass an order on a host of petitions, I mean, some boundary thing might
Has
be
to be, my
required.
lord, yes.
Might be required.
True, my lord. You're
I'll-
absolutely right.
We'll have to see. Okay, then. What else?
My lord, actually, what we are concerned with in these cases is that whether, my lord, their cases were considered.
No, you're concerned with only one small portion of the thing. But when we decide, I mean, this court will have to decide the entire gamut of things. You are only looking at it from your angle, from your perspective. Now, when we decide the issue, we have to decide it by taking into consideration all the issues going to be raised by all the other petitioners. You are looking at it from only your angle, which of course, as a lawyer, you are supposed to. But then you also have a duty to ensure that, we pass a well-rounded order, which is, of course, will always be challenged anyway.
My lord, if any particular applicant, my lord, that application does not come within the scheme, they may not be entitled for consideration.
Correct. Correct.
But those who have applied on time or within reasonable time.
So that is why you see, because out here the judgment that you have relied upon, again that they're harping on,
Applying on
approach
time.
the authorities on time.
Yes, yes.
So that is one very important factor.
Very important aspect.
Yes.
I
If they have
quite agree.
approached on time, then maybe, you see, then it is the duty on the part of the respondents to have done their work as in time.
Yes.
But if the petitioners have not approached on time,
Then
can they insist that they should have also, the respondent should also
my
work
lord,
on
that
time?
equity will not help them. My lord. Equity will not help them.
It's like that in a blanket ban, there cannot be blanket consideration for everyone.
Because, my lord, there cannot be, what we are on is that, my lord, there cannot be a blanket, my lord, closure of consideration of the people who have applied on time. And, my lord, that is more so because of the fact that, my lord, this honorable court has directed it to do it in a particular time. And my lord, relying on that, they have themselves, my lord, they evolve the principles. That also required that you have to get all those, my lord, considered within a period of 6 months. That they have not done. And in Devabhuta theory, my lord, there are no scheme. We have got a scheme, my lord, a clear-cut scheme and policy.
So basically what you're trying to say is that they could not have made the scheme or its modification of the scheme on the basis of Devabhrata's
True,
case, where in fact the decision of the DLC or the SSC could have been on the lines of Deborah Bata in each, depending on the application, each facts of each case. But that there could not have been a blanket decision to, by basically they're usurping the decision to be taken by the DLC or the SSC.
Yeah, quite true, my lord. What I, my lord, further want to add is that, my lord, we don't want compassion. We want implementation of your own policy of compassion.
You don't want?
We don't want additional compassion. Compassion is always there in the, my lord, scheme that you have prepared. We want consideration on that, under that.
Okay, now consideration under which scheme? Which OM?
2015, my lord,
15.
my lord. That is the only scheme which is, my lord, alive as on.
Applicable.
And that has also, my lord, taken consideration of the earlier cases pending, my lord, the policy, this, my lord, so many policies, they have framed policy 1, 2, 3, 4, my lord. Under that, my lord, on those principles, principle 1, 2, 3, 4, they are entitled to consideration.
Okay, any other submissions?
My lord, the Rajasthan High Court is also, my lord, in the same line. I will not repeat that, my lord. It has also discussed these relevant paragraphs of the, my lord, Debarpura Tiwari. And
So basically, you're saying that Debarpata Tiwari, there was no scheme for compassion appointment. Out here, there is a scheme.
there is a scheme.
Is that the only distinguishing factor?
Yes. Also on that basis, my lord, the foundation of the impugned notification is, my lord, Debarpura Tiwari. But, my lord, Debarpura Tiwari does not lay down the law which, my lord, they want to say in this impugned notification.
So it was on the basis of those facts. And as such, it'll be only an authority for that case. And the observations made can be applied by the authorities in individual case.
In individual cases, my lord, it has to consider each and every case, my lord. Your worship need not go into the particular facts because, my lord, policy is already there. On the basis of the policies, my lord, they have to consider and either allow or reject.
But we will have to see. So you mean to say the principles, but in that 2015 OM, the time limit for filing OM, is it there? The time limit for filing applications, it is there. How much? What is the time limit?
1 year.
1 year in the principal one.
Yes, my lord. Now, my lord, I do not know, my lord, whether I'll place the decisions, my lord, how to find out, my lord, whether a decision rendered by the Supreme Court is a, my lord, is a, my lord, Obiter, or it is a precedent and, my lord, decidendi. Shall I place the decision or may not be required?
Up to you, it's your case.
My lord.
So
I'll place,
then,
my lord.
because you might.
Because, my lord, the foundation of the government's case is, my lord, Debarpura Tiwari. And, my lord, my lord, first argument is that, my lord, Debarpura Tiwari, my lord, does not lay down any law, any precedent which has to be put. On that, my lord, it would be in a career institute.
2006.
My lord, this is
Now this is again, what is this? Compassion appointment.
Rajasthan High Court. I'm not reading, my lord, because more or less the Calcutta High Court judgment has. This is also division bench judgment. It may have, my lord, persuasive value, but then, my lord, that will be my argument. And then, my lord, this is the Career Institute Education Society versus Om Sri Thakurji Educational Trust.
What is the case name?
This is, my lord,
Acha, Career Institute, yes.
2023 live law, Supreme Court. It's a small judgment, my lord. May I read it?
Huh?
It's a small judgment, my lord.
Yes, yes.
We do not find any merit in the present special leave petition and hence the same are dismissed. However, we'd like to record some reasons for dismissal of the present special leave petition. The judgment in Vidya Grolia and others versus Duga Trading Corporation did not examine and decide the issue of effect of unstamped or understamped underlying contract on the arbitration agreement as this issue and the question has not been decided in Vidya
Dolia.
Dolia. The decision is not a precedent on this question. Vidya Dolia did refer to the judgment in the case of Garware Wall Ropes Limited versus Coastal Marine Construction and Engineering Limited, but in a different context, as is evident from the paragraph 146, 147.1 of the judgment, which are reproduced below. We now proceed to examine the question whether the existence in section 11 merely refers to contract formation, whether there is an arbitration agreement, and excludes the question of enforcement validity. And therefore, the latter falls outside the jurisdiction of the court at the referral stage. On jurisprudentially and textualism, it is possible to differentiate between existence of an agreement, arbitration agreement, and validity of an arbitration agreement. Such interpretation can draw support from the plain meaning of the word existence. However, it is equally possible jurisprudentially and on contextualism to hold that an agreement has no existence if it is not enforceable and not binding. Existence of an arbitration agreement presupposes a valid agreement which would be enforced by the court by relegating to, the parties to arbitration. Legalistic and plain meaning interpretation would be contrary to the contextual background, including the definition clause, and would result in unpalatable consequences. A reasonable and just interpretation of existence requires understanding of the context, the purpose, and the relevant legal norms applicable for binding and enforceable arbitration agreement. An agreement evidenced in writing has no meaning unless the parties can be compelled to adhere to and abide by the terms. A party cannot sue and the claim arise based on an unenforceable document. Thus, there are good reasons to hold that an arbitration agreement exists only when it is valid and legal. A void and unenforceable understanding is no agreement to do anything. These are the facts, my lord. Then, my lord, your lordship may skip and come to the last part. It is apparent from the aforementioned paragraphs that the reference to the decision in Garware Wall Ropes was made to interpret the word existence and whether an invalid arbitration agreement can be said to exist. The examination was to decide who decides existence of an arbitration agreement in the context of section 1811 of the Arbitration and Conciliation Act. The distinction between obiter dicta and ratio decidendi in a judgment as a proposition of law has been examined by several judgments of this court, but we would like to refer to two, namely State of Gujarat and others versus Utility Users Welfare Association and Jayant Kumar Verma versus Union of India. The first judgment in State of Gujarat applies what is called the inversion test. So this is the test that has been laid down, my lord, to determine whether it is a obiter or this is a my lord ratio decidendi. The inversion test to identify what is ratio decidendi in a judgment. To test whether a particular proposition of law is to be treated as a ratio decidendi of the case, the proposition is to be inversed. That is to remove from the text of the judgment as if it did not exist. If the conclusion of the case would still have been the same, even without examining the proposition, then it cannot be regarded as a ratio decidendi of the case. In Jayant Kumar, this court has referred to an earlier decision of this court in Dalbir Singh versus State of Punjab to state that it is not the finding of material facts, direct and inferential, but the statement of the principles of law applicable to the legal problems disclosed by the fact, which is the vital element in the decision and operates as a precedent. Even the conclusion does not operate as a precedent, albeit operates as a res judicata. Thus, it is not everything said by a judge when giving a judgment that constitutes a precedent. The only thing in a judge's decision binding as a legal precedent is the principle upon which the case is decided. And for this reason, it is important to analyze a decision and isolate from it if the obiter dicta.
Now, please simplify it.
My lord.
Please simplify it. The first part, the first para. That in that, the test, the inversion test,
My lord, the ratio of a case, as your lordship knows, my lord, has to be understood on the background of the facts of the case.
correct,
This has been laid down by the Supreme Court,
Correct.
your lordship is aware.
correct.
Now, my lord, in the book theory, the facts are entirely different. There was no scheme. Here is a scheme, my lord, where the government has.
No, I just tried to understand it better, this paragraph 1 of this judgment, the second last paragraph of the judgment, the inversion test.
Inverse, this is, my lord, a little difficult to understand. Difficult.
You're the one who's supposed to make it easier for us to understand.
My lord, this is Supreme Court which has said, my lord, this is the test to be applied.
No, I understand that this is a test, but I'm slightly confused. I could understand with the ultimate decision here that it cannot be regarded as the ratio decidendi. This part, I think, is it a mistake?
No, this.
When the proposition is taken away
My lord,
and the result still remains the same, then it should be the ratio decidendi.
so, yes, my lord.
Shouldn't it be?
Yes, my lord.
But then it says here it should not be.
My lord, if I'll read that again, my lord. That's second last but one. The first judgment in state of Gujarat so and so applies what is called the inversion test to identify what is ratio decidendi in a judgment. To test whether a particular proposition of law is to be treated as ratio decidendi of the case, the proposition is to be inversed. That is to remove the text of the judgment as if it did not exist. If the conclusion of the case would still have the same, even without examining the proposition, then it cannot be regarded as ratio decidendi of the case. To not overlay, no? Huh? Then it is not the ratio decidendi. It is the ratio decidendi. I think, my lord, this should be the ratio decidendi.
I don't know. I'm asking you.
Yes.
I'm slightly confused. You are relying upon the judgment. Now I'm trying to understand the. I'm trying to understand the judgment.
Cannot be regarded as a ratio decidendi. My lord, if the facts are taken away,
Then
if without the facts, my lord,
if without the fact, if the same result comes about,
yes, my lord,
then what does it mean?
it is not the ratio decidendi. My lord.
No,
That is what is
it
said.
is. It has to be, because the principle will still be the same. You see, then because if it's an obiter dicta, then it will be on the facts of that case.
Yes.
But when the facts are taken away, and if the result is still the same, then that has to be made on the basis of some principle, which in that case wouldn't it be ratio decidendi?
My lord, in that context, my lord, if we read 7.5,
No, I'm just trying to understand this. I'm not understanding this. I understand what you're trying to say, but this test that the Supreme Court has said, I'm not understanding it. So I'm asking you, because you're the one who is brought out this judgment. So I'm asking you how do I understand it? How will you make me understand this?
no, my lord, for that, my lord, to apply this, and my lord, make it clear, my lord, we have to read that particular paragraph on which, my lord, the government is relying.
No, I'm not on that. I'm not on that. Forget that government. Forget this case. On the law. On this, how to decide whether a decision is an obiter dicta or a ratio decidendi. Now, when you apply the inversion test and you take out the proposition and still come to the same conclusion, that conclusion, that means will have to be based on some principle, not on the basis of facts, but on the basis of some principle. If it's on the basis of some principle, won't it be a ratio decidendi? Because obiter dicta cannot be on the basis of some principle. It will have to be on the basis of the facts of the case. So that's what I'm not understanding this case. This decision. Maybe I'm wrong. You see, because even I'm still trying to understand this. You know, anyways, any other case regarding this ratio decidendi and obiter dicta?
One more case, my lord. খালি যে দিলা এটা কি আছিল? Dalu Dayalu Mahasabha, my lord, Supreme Court. Dalu Dayalu. Paragraph 19, Maulvi. Paragraph 19, 19.
19. Yes.
The judgment of a court, it is right, should not be interpreted as a statute. The meaning of the word used in a judgment must be found out on the backdrop of the fact of the case. The court, while passing a judgment, cannot take away the right of the successful party indirectly, which it cannot do directly. An observation made by a superior court is not binding. What would be binding is the ratio of the decision. Such a decision must be arrived at upon entering into the merits of the issues involved in the case. So, madam, on the facts, the court has to go to the facts of the case to understand the ratio.
Case. The thing that differentiates this case, your cases, and Deborah Bhatta's cases,
On facts.
is that there it is on facts.
Yes.
Because there was no scheme. Here there is a scheme. So it's so out here also. So out here, so you're saying that is the obiter dicta.
Yes.
But here, again, it says that it has to go to the merits of the issues.
Yes, ma'am.
Huh.
So, if we go to the merits of the
Merits of the issues, but is the decision to be based on the merits only or based on some principle of law?
merits on the merits means the merits in the facts of that case.
Okay.
It পড়িব নি স্যার একটু খালি মানে রিলাই করছিল স্কিম টু স্কিম টু স্কিম টু স্যার প্যারাগ্রাফ 5
Only one more, my lord, judgment, I just read, my lord, one paragraph. Ekon diso nai, State of Madhya Pradesh versus Shyam Kumar Yadav. Ekon diyasen na goto. State of Madhya Pradesh, yes. State of Madhya Pradesh versus Shyam Kumar Yadav. Only one paragraph I'll read, my lord.
Let me find out where it is. State of Madhya. Yes. This is just a minute. This is SLP C 25609 of 2018. Yes.
Only paragraph 5, my.
Yes.
It is true that an employee engaged on daily wages has no legally vested right to seek regulation of his service. However, if competent authority takes a policy decision within the permissible framework, its benefits must be extended to all those who fall within the parameters of such a policy. Authorities cannot be permitted to pick and choose in such circumstances.
But this is if you are relying on this.
This is on the basis of the fact that, my lord, even, my lord, when this notification was issued,
No, but this is very incomplete. This is incomplete for the simple reason that it's like you riding piggyback on the decision of some other person.
Yes.
You know what I
Yes,
mean?
yes, yes.
Basically, no doubt that this policy decision will have to be made applicable to everybody, but that will be subject to certain exceptions. Like supposing a person is entitled to apply for this compassionate appointment within, say, 1 year, like you said, but he applies after 10 years, or after 15 years, or 20 years.
Then
Policy might be applicable, but then, but there are exceptions which,
exceptions have already been carved out in the policy they have framed. my lord.
okay, so that 1 year is there.
Complete the, my lord, permissible framework. My lord, on the other day, I had made some submissions, my lord, in the additional affidavit, we have filed certain documents to show that even after, my lord, 2017 notification came in, the authorities has considered and given appointment to some.
After
Yes, my lord.
2017.
That is a violation of the, my lord, Article 40.
But
Because,
that's a
my lord,
different thing. Mistake doesn't confer any right.
my lord, the same principles, 2015 notification that has been applied in case of some petitioners, and we have been left out. We are not challenging their, my lord, appointment on competition.
So after the 2017 notifications, some persons were appointed. Okay. Anyway, that's a different thing. That's a different issue.
Yeah, but that is on the basis of, my lord, the violation of Article 14, because, my lord, you have to treat everyone equally, my lord, consider, only consideration. Some cases have been.
Treat everyone equally means he'll have to get the family, compassionate family pension, not the other way around.
To consideration.
You,
my lord.
huh?
Consideration. I am.
Whatever.
Consideration. You have
No, you
consideration.
cannot. No, once the 2015 notification has been superseded by the 2017 notification, and supposing Mr. A was to be considered as per the 2017 notification, but has been considered and appointed in terms of the 2015 notification, that doesn't give you any right.
No, my lord. They have been considered on the basis of the 2015 notification.
That's what I'm saying. They were considered under 2015, though they should have been given compassionate family pension under the 2017.
No, my lord.
No.
What I say is that, my lord, they have been considered, they are like us, they
Ah.
have been considered under 2015 scheme, my lord, notification and given appointment. The same ought to have been done in case of the petitioners also.
Given appointment when?
Given appointment, my lord, after the 2017, my lord. If your lordship kindly.
That's what I'm saying. After 2017, naturally they'll be entitled, because 2017 notification is only applicable for those who are born. I mean, who is when death has occurred after 1/4/2000, on 1/4/2017.
Yes.
So, if his claim is with regard to a death which happened prior to 1/4/2017, then naturally he'll be considered under the 2015
That is
notification.
what, my lord, we are asking for. Eventually, you're asking for that, my lord.
Those persons did not die after 1/4. They did.
That's no, now that is there, but now there's a 24 notification. I know what you're asking. So 24 notification is blocking you.
Yes, that consideration. That is precisely the case. My lord, I am sorry for giving my lord, illegible copies.
Huh?
Illegible copies I had given, my lord, I am sorry for that.
Yes. I had to turn to your writ petitions. They're better copies in your writ petitions. You could have easily taken it out. Anyway,
I'm grateful to your lordship, my lord, giving me a patient hearing.
that's all. Anybody else? No.
I don't know, my lord, on facts if they want to.
What do you want? Not on facts. This is the law. How much time? What 10 minutes? What? Some citation or what? Just let it. Yes.
Sub judgment and notification lordship.
How many judgments?
No, only 3, 4, my lord. My lord, here in this case, my lord, this under the 2015 notification, my lord, clause 1 was, my lord, under challenge before this honorable court, my lord, once, my lord. Here, my lord, it was in this notification, lordship, it is, my lord, in the bunch, my lord, page 11, my lord. Clause 1, my lord. It was provided that, my lord, balance service 3 years is necessary, my lord, for the disease employee.
Yeah.
For applying compassionate appointment, my lord, before the completed.
Correct.
Yes, my lord. And my lord, this clause was challenged, my lord, before this honorable court.
We're not on that.
My lord, only, my lord, under what circumstances, my lord, one notification may go, my lord. Because,
Okay.
my lord, various judgments cited.
Okay.
Therefore, my lord, I have given this judgment, my lord.
Which one? Which one?
My lord,
WPC?
WBC, my lord, 1646,
46.
my lord. Under, my lord, paragraph 14, my lord.
Para 14.
Under paragraph 14, my lord, I'm directly going to the, my lord, judgment quoted, my lord. Right hand side, my lord, Supreme Court judgment, my lord, was cited and quoted paragraph 14, my lord.
Yes.
What follows from the above is that in order to pass the test of reasonable classification, two conditions must be fulfilled. That the classification must be founded on an intelligible differentia which distinguishes persons or things that are grouped together from other left out of the group, and two, that the differentia must have a rational relation to the object sought to be achieved by the statute in question. If the government fails to support its action of classification on the touchstone of the principle whether the classification is reasonable, having an intelligible differentia and rational basis germane to the purpose, the classification has to be held as arbitrary and discriminatory. So, my lord, here, my lord, my learned senior counsel lastly submitted that, my lord, after, my lord, 2017 notification. My lord, there, my lord, stated there, my lord, in the 2017 notification, my lord, those who are dying, my lord, on and from 1 April 2017, they will be given, my lord, a compassionate family pension. And those who died before that date, my lord, they will be given compassionate appointment, my lord. We are on that category, my lord. And from that category, my lord, they are every year, they are giving appointments, my lord. From senior candidate or junior candidate, maybe, my lord, they are giving appointment admittedly, my lord. But suddenly, my lord, they are taking, my lord, some observation part of the Honorable Supreme Court, my lord. They, my lord, they filed.
You're saying the same thing that you
Yes,
say.
sir.
What new thing are you
Therefore,
saying?
my lord, this, my lord, notification violates equality also, my lord.
Huh?
Equality, my lord, clause of the constitution is also violated because, my lord, same group we are, my lord, entitled for consideration of compassionate appointment, my lord. They considered some people of our, my lord, group, my lord, appointed, my lord. That is before, my lord, 2017, my lord. Hence, for some of us, my lord, they have passed this notification. Therefore, this notification on this count also not sustainable in law, my lord. And, my lord, accordingly, this was, my lord, after, my lord, notification was modified that, my lord, 3 years was not necessary, my lord. Only, my lord, principle.
Anything else?
My lord, another, my lord, Supreme Court judgment, my lord, I have given before your lordship 2000, my lord, ratio decidendi Obiter dicta, my lord, 2000, my lord, I have given the copy, my lord,
Yes.
hard copy, 2002.
4
SCC, my lord.
68. Yes. Para?
Paragraph 7, my lord.
Yes.
Paragraph 7, my lord, so far as the first question is concerned, Article 141 of the Constitution unequivocally indicates that the law declared by the Supreme Court shall be binding on all the courts within the territory of India. The aforesaid article empowers the Supreme Court to declare the law. It is therefore an essential function of the court to interpret a legislation. The statement of the court on matter other than law-like facts may also no binding force as the facts of the two cases may not be similar. But what is binding is the ratio of the decision and not any findings of fact. It is the principle found out upon a reading of a judgment as a whole. In the light of the question before the court that forms the ratio and not any particular words or sentence that determine whether a decision has declared law, it cannot be said to be a law when a point is disposed of on a concession and what is binding in the principle
What is
underlying.
binding is the principle, not
Yes,
in the.
yes, Mala.
Is the principle.
Underlying a decision. A judgment of the court has to be read in the context of questions which arose for the consideration in the case in which the judgment was delivered. An obiter dictum, as distinguished from a ratio decidendi, is an observation by the court on a legal question suggested in a case before it, but not arising in such manner as to require a decision. Such a obiter may not.
Okay, I
have a
think
binding-
we've read.
Yes, sir. Here in this case, my lord, in the Devabrata, my lord, Tiwari case, my lord, this observation is not at all, my lord, required, apparently not at all required in the, my lord, the context of that case, my lord. In that case, my lord, ultimately, Supreme Court found that, my lord, from those petitioners before the Supreme Court, my lord, they are not entitled for compassionate appointment at all, my lord. Because, my lord, they are, my lord, in a, my lord, a local body employee, and, my lord, the compassionate appointment scheme was not there, my lord.
Why you are repeating the same thing
Yes.
over and over again?
Therefore, my lord, this observation made by the honorable
Okay, yes,
Supreme
I
Court
heard.
is not, my lord,
I
yeah,
think
my
I
lord.
heard you, Mr. Austin. You are repeating the same thing.
Yes, my lord. Then another, just only to show, my lord, judgment, my lord, different judgment. My lord, another judgment I have given, my lord, recently, honorable single bench of this court passed, my lord. This is, my lord, WPC 2277/2024, my lord. Here, some candidates who, my lord, were, my lord, passed by the DLC, but not considering by the SLC. This honorable court, my lord, passed this detailed judgment, my lord, considering all aspects of the matter, that, my lord, this SLC should consider all those cases, my lord. Therefore, my lord, in this case, my lord, these petitioners are entitled, my lord, for consideration, my lord, of compassionate appointment, my lord. At least, my lord, my humble submission is that, my lord, other petitioners may not agree with me, my lord. Those who are rejected, my lord, or those whose candidates are, my lord, yet not considered, my lord, after long date, my lord, they may not be, my lord, entitled, my lord. This is my lord, separate argument, my lord. But those who are, my lord, already considered by the DLC, my lord, and they are pending in the SLC, or those who are, my lord, holding the order of this honorable court, my lord, for
So
consideration.
he's championing his case only.
Yes,
He's saying the other cases you
they
can
are
throw down the
campaigning,
drain.
my lord. But I am campaigning for everybody, my lord. But
No, yeah. They are all laughing behind you. They are saying that look what is he doing? He's only thinking of himself.
with all respect, my lord, I am campaigning for everybody, my lord. But, my lord, apart from that, my lord, I am specially submitting that, my lord, separately, that their case is, my lord, best case, my lord, those whose cases are already
Their
considered.
cases I can throw away, but not yours.
Yes. And, my lord, our case is otherwise separate, my lord. We are under some, my lord, the rules, my lord, guidelines, my lord. That about, my lord, Achyut Ranjan Das, my lord. I have given this, my lord, in the bunch of this copies, my lord. There is all the notification I have given, my lord. And in the Achyut Ranjan Das, my lord, they have given already guidelines from this court, my lord, how to consider, my lord. We are protected by this, my lord, the judgment also, my lord. Therefore, my lord, Devabrata Tiwari judgment, they, my lord, blanket, my lord, the application on in all these cases, my lord.
Devabrata is Supreme Court.
Yes, Supreme Court.
Achyut Ranjan Das is single bench High Court.
Yes, but this is on that particular case, my lord. And this is observation, my lord. It was not necessary, my lord, this observation to decide this case before the honorable Supreme Court, my lord. Because they were, my lord, not eligible, my lord, for compassionate appointment, my lord. But lastly, it is said that even they are, my lord, eligible, they are, my lord, delayed case. Therefore, my lord, it is not necessary. And that case was, my lord,
What is the time period for filing application for compassionate appointment?
in Assam, my lord, 1 year, my lord. And Devabrata Tiwari case was 16 years delayed, my lord. And before your lordship, there are many cases, my lord, 5, 6 years, 7 years, 8 years delayed cases are there, my lord. Maximum cases are, my lord, 10 years delayed case. But in the Devabrata Tiwari, my lord, it was, my lord, 16 years delayed matter, my lord. The my lord, already, my lord, they are, my lord, now at present, my lord, they are, my lord, getting full benefit, my lord, service benefit. Those people are only, my lord, they are getting, my lord, compassionate appointment if eligible, subject to other criteria, my lord. Yeah, my lord, government should show their, my lord, big heart, my lord, for those, my lord, people, my lord.
But they've got very small pocket.
Yes, my lord.
Big heart, small pocket. What to do?
They will serve against the post, my lord. They are poor people, my lord. They give, my lord, last concession. Already, my lord, abolished. Scheme is admittedly abolished since 2017, my lord. Only few people, my lord, hardly 100, 200 people will get job, my lord, because of, my lord, the death of their bread earner, my lord. Government should show, my lord, some concession and
Yeah, lucky government is giving you this
Yes, sir.
compassionate family pension. In some states, nothing. Nothing is being given.
Yes, my lord. Nowadays, my lord, all are getting benefit, my lord. But we 5% only, my lord.
5% is something better than zero.
Yes, my lord. Of course. But they are not nowadays, my lord, they are totally abolished. My lord, no SLC, no DLC. Their circular says, my lord. On humanitarian ground, the last, my lord, everything is last finished. Compassionate appointment is already abolished, my lord.
I will have to identify your cases in particular and give them special treatment.
No, my lord. I am for everybody, my lord.
Okay.
Development.
In my case, what even when there are 3 petitioners,
Oh, in your case?
yes, madam, there are 3 petitioners. The Sericulture department filed an affidavit stating that in respect of 1 petitioner, my case will be placed in the next SLC meeting. There is a direction passed by the Honorable Court. And in respect of other petitioner, already DLC and SLC has recommended my name. But due to
So you want to withdraw your case or what?
they should implement my case as per their own decision. They have filed an affidavit stating that the case of the petitioner number 2 will be placed.
Then why did you put your case along with these other cases?
No,
We should have decided
this case has
separately.
already been tagged along with the series matter.
Not without your permission. You must have wanted it tagged. It cannot be done on our own.
Point out.
Yes.
May it please your lordship. So my whole submission will roam around the word immediacy. If we look at the word immediacy, lordship, that means that immediate action that has to be taken by the authorities to give succor to the bereaved family. So in all the Supreme Court cases, including Debabrata Tiwari's case, what is considered by the Honorable Court is that after the death in the family should be given some help so that they can recover the financial difficulties faced due to the death of the main bread earner. If we look at these batches of writ petitions, I'll give one copy. The persons who died, most of them have who died. If lordship is pleased to take, I will give it. It is already there. In writ petition number 1, the person died in 2010. Second is 2009. Third is 2005. Fourth is 2015. Then 2006, 2007. Then somebody have not disclosed then serial number. 2001, 2014, 2006, 2007. 8 is 2009. 13, 9, 9, 7, 2017, 2016. Few writ petitioners did not disclose the date. Then serial number 16, 1999. If they had appointment, they would have come for pension now before this honorable court. Then 17 is 15, 16, 98. Then another 18 is 13, 19 is 15. Then serial number 20, 16, 13, 22. Then next page is 2006. Then 2007. And if Lordship is pleased to see, the age of the writ petitioner, some are even crossing 50 years. Some are in their late 40s. So, and if Lordship is pleased to come to page serial number last, 39 and 40, last page. The person died in 2001 and serial number 40, 1998 and 2004. So none of this case deserves any sympathy of this honorable court, and Lordship has given sufficient time in hearing these batches of cases. No doubt they have a legal right to argue their cases. But whether any of the principles enunciated by the Supreme Court in various cases from 1980s have considered this kind of litigations. We are in 2025, Lordship, and we are considering cases of 1998 for compassionate appointment. That is not the spirit of any of the judgments. Lot of things has been said. I will cut short my arguments. Lot of things has been said that regarding Obiter, dicta and ratio decidendi. What are the major issues and facts considered in Debabrata Tiwari's case? Number one, elapse of several years or decades from the death of the person in the family. That is one factor which is considered. The Debabrata Tiwari's case also considered the situation when there is a scheme and where there is an absence of scheme. When that means there is no scheme. Both the situations are visualized. Whether the appointment could not be given due to delay on the part of the beneficiary or delay due to the inaction of the department. Both the situations are taken into consideration while laying down the principles. Whether there is any pending honorable court's order for their appointment or tribunal's order. All these situations, these are general situations which are taken into consideration while framing this policy.
The
Or the
last,
guidelines?
the last one you said?
Court's order. So if any of the cases of these batches of about 50 cases do not fall into this category, that's why I'll not take much time. Debabrata Saikya cleanses the whole issue. All these issues which they want to agitate fall within the parameters of these various criteria or verticals. All their cases, whatever case we pick up.
What they're basically saying is that this OM is there. This OM that decision taken by the government, that could have been taken by the DLC.
Yes, Lordship.
So, supposing we send it to the government to take a decision on each and every of these things. Without
End result will be same because end result will be same.
Correct.
End result will be same. So where that will be a mere formality in my humble submission. They have to point out what is the flaw in the notification, which is put to challenge. Because their prayer is, one is that they want Mandamus of this honorable court for appointment of a person died in 98 also, 2014 also, 2006 also, 2001 also. They want direction. That is one Mandamus part. The other part is, I have seen the main one, the petition which I am relying, that setting aside this policy of 18/9/2024, to set aside a policy, they have to make out a case, Lordship, on 2 or 3 basic principles. That there should be arbitrariness, there should be some violation of the Constitution, legalities, and it should be malicious. From our policy, if I am allowed to place that policy, Lordship, for the time being in a very quick manner. In my affidavit, Lordship, is maybe please to take my affidavit.
In which?
In WPC 5079.
Item 5.
5079.
Yes.
Item 5, which your lordship was.
Item, there is 5067. No, item, wait.
5079,
5079.
Anju Manwara Begum and
Yes.
11 others.
Uh-huh.
So now, one more thing, Lordship. Anju Manwara Begum and 11 others. Whether these 11 persons fact situation is identical to come up in a single writ petition? On these grounds also, the writ petitioners are maintainable in the present form. How can the 11 and 12 person agitate before this honorable court
Different
for
cause
their
of action.
different rights
And not disclosing date.
and not disclosing their date, the day of the date also? This is how the petitions are being filed. And on top of that, Supreme Court in number of cases says this is not a right. Right to a compassionate appointment, it is not an enforceable or indefeasible right. No right has been there. It is a welfare scheme of the government. So they cannot say that there is a violation of rights. They are arguing violation of Article 14 also. For Article 14, Lordship, a right has to be accrued in their favor. Till now, it is a settled position of law that right is not there in case of any of the writ petitioners. And the government, in this base wisdom, have already transformed its policy in 2017. We always had that problem. What is the background? There is a 5% vacancy in which the compassionate appointee can be given. If there are about 10 persons applying and the 5% quota is 1 or 2, 8 will not get. That is why government, what they have done, that all the persons, their families, should get the same salary as the person was earning during his lifetime. That will continue till the time of his superannuation. If the person died at the age of 47, suppose, the family will get his salary along with annual increments till he attains the age of superannuation, that is 60 years. After 6 years, the family will get the normal pension, family pension. That is the scheme the government brought in so that nobody is deprived. We do not have to find out which family is more distressed. So there is a uniformity in this welfare scheme also. All these persons have died before 2015. Today we are 10 years late. In any situation, because I'll place straight away, I'll go to Debarbat Tiwari's case. All these situations were visualized. Their case, Lordship, either it was due to lack of vacancy, they did not get the post. Many of them did not get because there is lack of vacancy. On the other hand, there is lacuna on the part of the government also. There was inaction or delay on the part of the government also in not taking a final decision, maybe for various administrative reasons. But thought and due diligence has also have to be done regarding each individual case. In that situation, whether Debarbat Tiwari's case has considered that situation or not. Paragraph 7.5 very clearly says, inaction on the part of the government as well as lack of vacancy, both situations are considered while framing the policy or the guidelines given by the Honorable.
What about cases where the High Court has said that it should be
Even
reconsidered?
that situation is also taken into consideration. They have relied upon a judgment of State of Uttaranchal versus Shiv Saran Bhandari, 2013-12 SCC, page 179. Paragraph 19 they have quoted. May I read it, Lordship? From the aforesaid authorities, it is clear as crystal that even if the court or tribunal directs for consideration of representation relating to a stale claim or debt grievance, it does not give rise to a fresh cause of action. The debt cause of action cannot rise like a phoenix. Similarly, a mere submission of representation to the competent authority does not arrest time. So
No.
all these situations are taken into consideration.
No, but then you see.
If there's a specific and they appoint him, those cases are not here.
When there is a specific direction.
Where is that kind of case?
No, there is, I think, there is one or two cases.
Let them come, then there's a violation of the court's order, then that will come under contempt proceedings.
No. When there is a court order,
For consider, that part is already considered.
where in the OM, it's not there.
Let me see. High Court, what High Court, Honorable Court would have passed? Honorable Court would pass,
reconsider.
either give appointment
No, only
or
to reconsider.
consider their case.
To reconsider.
That consideration situation is already there, Lordship. That there are delay in considering those cases.
No, but then this is a decision of the decision of the High Court Has-
let them segregate these cases, Lordship, otherwise it will be difficult. If there is a specific direction of the Honorable Court, they should fall into a separate category. Which are those cases? They are not arguing those cases here.
No,
They are not showing. I have not seen, I was hearing for their matters for last 2 days.
No, I have seen, 2-3 cases I've seen.
Then let them segregate. Even if the case has to be considered now on the basis of Honorable High Court's order, it has to be considered on the basis of the policy which is in place. That is also another point which has been clarified here.
It appears, as per this policy of yours,
Yes.
it is not a policy. It is basically a decision that taken that those cases prior to 31st March 2017 shall not be considered.
No, it is not like that, Lordship. In 2017, the policy came.
First
The-
April.
Yes. First, that one category thereafter, that is a prospective effect, they will all be entitled for family
So
pension.
that will
That-
carry on.
They are also, the policy said, the persons who died earlier with a particular deadline, date is given. 31/3/2017. They will be considered under the 2015 policy.
Correct.
So whoever has got the benefit of the 2015 policy, their cases, now few cases they did not get appointment. It is not a case that others did not get appointment.
You see, this 2015, the principles in the 2015 notification, the principle number 1, I think. Where is that?
Yes.
Principle number 1. Where is this?
2015 Lordship,
Yes,
page, Lordship, what Lordship is referring?
principle 1, principle 1. At page 4. Principle 1, on top.
Yes.
All pending applications against existing vacancies as per the quota earmarked so and so, so and so, so and so shall be decided in accordance with the proposed directions to be laid down in the present order.
All pending application against the existing vacancy as per the quota earmark, including the cases of the petitioners in the present cases and all others who may not be before the court shall be decided in accordance with the proposed direction as laid down in the present order and also in accordance with the principles noted in the preceding paragraphs of this order. This will be done within a period of 4 months from today. The present direction naturally has to be considered as one-time measure in view of the subsequent directions as laid down in the subsequent paragraphs. This is of 2015.
So, when this notification is there and the
1st
directions
June
have been,
2015.
Yes,
Yes.
2015. Why don't you take a decision on the basis of this, whatever decision you take?
No, Lordship, we cannot take, unless Lordship directs, we cannot go because we have a existing policy or the decision or the notification which is put to challenge. That is of 2024. We can take all decisions, but all decisions will ultimately be in conflict with the principle laid down by these honorable courts in umpteen number of cases as well as by the Supreme Court, that nobody should get benefit beyond a period of 2 years. It will dilute everything.
No, this is, you see, we are not.
Now, nobody's prayer is that they have to follow this principle or the 2015 policy. Where is that prayer?
No.
They
When-
have to make a specific prayer.
No, when they
And
challenge.
this is no more in force now
No,
from
but
the government's
but
perspective.
when they challenge the 24 notification,
Lordship.
then it implies that they want that this
They
notification
can
should
want
be applied.
everything. They can want the moon also. But we can give what we have under the policy, under the government's scheme of things. What we have done, we could have given 5% giving is very easy for the government. but the same salary without work for the remaining, suppose a person died at 26 years. For 35 years, government is paying to that family the same salary without exerting any work. We have to see that perspective also.
No, you see, the decision, the reasoning of the OM, there, I don't find it anything wrong. as such.
Absolutely, that is what I am trying to say.
But
Lordship.
no, but the problem is that these decisions, I think, will have to be decided on a case-to-case basis.
Then Lordship may direct us. We can, if Lordship directs, will be easy. What will be the answer, Lordship? Let me be very honest. That on the basis of 2024 policy and Deborah's case, all cases are closed. That will be the order. That is given in the OM itself. That is given in the OM itself. The last paragraph, if Lordship is pleased to take my policy page 62. In view of the circumstances mentioned above, it has been decided. So that decision is taken through this notification. It has been decided that no cases for appointment on compassionate ground to the family members of the state government employees who died in harness or retired prematurely on being declared permanently incapacitated for service or missing, and those whereabouts is not known prior to 31/3/2007 shall be entertained by any administrative department authority for any reason whatsoever, nor be placed before SLC DLC for recommendation of candidates for appointment on compassionate ground. The cases of employees who die or died in harness after 31/3/2017 have been taken care of by the Compassionate Family Pension Scheme in lieu of compassionate appointment by notification dated 14/9/2007. So that decision is also there. Unless Lordship interferes with this policy, it will be very difficult for us on our own or so modo.
Correct.
If they have to show that this paragraph is bad in law. And we have taken this in view of the circumstances above, we have stated the circumstances. The principles laid down in Deborah. And the Deborah's case, Lordship, in 5 minutes, I'll complete my submission. In Deborah's case, everything is considered, whether there is a policy in force, whether there is lack of policy or no policy at all. I am not going to the factual position. Points for consideration they have taken, and policy for compassionate, paragraph 7, Lordship.
Yes.
Policy for compassionate appointment, the rationale. It is a general principle, Lordship. It has nothing to do with the factual metrics of the Calcutta municipal authorities. The majesty of death is that it is a great leveler, for it makes no distinction between young and the old or the rich and the poor. Death being as a consequence of birth at some point of time is inevitable for every being. Thus, while death is certain, its timing is uncertain. Further, a deceased employee does not always leave behind valuable assets. He may at times leave behind poverty to be faced by the immediate members of his family. Therefore, what should be done to ensure that death of an individual does not mean economic death for his family? The state's obligation in this regard, confined to its employee who died in harness, has given rise to schemes and rules providing for compassionate appointment of an eligible member of his family as an instance for providing immediate succor to such a family. Support for such a provision has been derived from the provisions of Part 4 of the Constitution, that is Article 39 of the Directive Principles of State Policy. So therefore, pausing here for a moment, the court has considered that the state must have a policy. So this part, Lordship, the state is having a policy. Honorable Supreme Court considered that point. 7.1. It may be apposite to refer to the following decisions of this court on the rationale behind the policy or scheme. That means existence of a policy. All the time they are saying that this judgment is not applicable because there is no policy. The Honorable Supreme Court has very clearly considered a situation where the state government has already floated a policy. It may be apposite to refer to the following decisions of this court on the rationale behind a policy or scheme for compassionate appointment and the considerations that ought to guide determination of claims for compassionate appointment. In Susma Gosai versus Union of India, this court observed that in all claims for appointment on compassionate appointment, there should not be delay in appointment. That the purpose of providing appointment on compassionate appointment is to mitigate hardship caused due to the death of the bread earner in the family. Such appointment should therefore be provided immediately to redeem the family in distress. In Umesh Kumar Nagpal, this court observed that the object for granting compassionate employment is to enable the family of a deceased government employee to tide over the sudden crisis by providing gainful employment to one of the dependent of the deceased who is eligible for such appointment. That mere death of an employee in harness does not entitle his family to such source of livelihood. The government or the public authority concerned has to examine the financial condition of the family of the deceased, and it is only if it is satisfied that, but for the provisions of employment, the family will not be able to meet the crisis, that a job be offered to the eligible member of the family, provide a scheme or rules provide for the same. So existence of a scheme is considered here. This court further clarified in the said case that the compassionate appointment is not vested right. So it is not a right. So they cannot say that there is a violation of Article 14. This court further clarified in the said case that the compassionate appointment is not a vested right which can be exercised at any time after the death of a government servant. That the object being to enable the family to get over the financial crisis which it faces at the time of death of the sole bread earner, compassionate appointment cannot be claimed and offered. Two components are there, claimed and offered after lapse of considerable amount of time and after the crisis is overcome. In Haryana for electricity board case, the court placed much emphasis on the need for immediacy, that is the word lordship which I am harping upon, in the manner in which the claim for compassionate appointments are made by the dependent and decided by the concerned authority. This court cautioned that it should not be forgotten that the object of compassionate appointment is to give succor to the family to tide over the sudden financial crisis that has befallen the dependents on account of the untimely demise of its sole bread earning member. Therefore, this court held that it would not be justified in directing appointment to the claimants therein on compassionate appointment 14 years after the death of the government employee. That such a direction would amount to treating a claim for compassionate appointment as though it was a matter of inheritance based on line of succession. This court in Haryana versus Ankur Gupta held that in order for a claim for compassionate appointment to be considered reasonable and permissible, it must be shown that a sudden crisis occurred in the family of the deceased as a result of death of an employee who had served the state and died while in service. It was further observed that appointment of compassionate appointment grounds cannot be claimed as a matter of right. Again, right is used. Cannot be made available to all types of posts irrespective of the nature of service rendered by the deceased employee. There is a consistent line of authority of this court on the principle that appointment on compassionate ground is given only for meeting the immediate unexpected hardship which is faced by the family by reasons of the death of the bread earner by Jagdish Prasad versus State of Bihar. When an appointment is made on compassionate ground, it should be kept confined only to the purpose it seeks to achieve. The idea being not to provide for endless compassion, by so and so. In the same vein, is the decision of this court in Mumtaz Yunis Mulani versus the Maharashtra, wherein it was declared that the appointment on compassionate ground is not a source of recruitment, but a means to enable the family of the deceased to get over a sudden financial crisis. So there are a lot of submission, especially my friend today towards the end said that their right is taken away. They will be deprived. All those people died about 15 years ago, 20 years ago, and they are saying that their right will be taken away and they are deprived. So that kind of submission, lordship, is not at all expected in kind of compassionate appointment. If the family is still in difficulty, that could have been a line of argument. In any case, lordship, may I read further? In state of Jammu versus Sajad Ahmed, the fact before this court was that the government employee, father of the applicant, died in March 1987. The application, I'm skipping, this is a particular fact situation. In Sasi Kumar's next case, this court, speaking through Justice so-and-so, observed that the compassionate appointment is an exception to the general rule that the appointment to any public post in the service of state has to be made on the basis of principles which accord to Article 14 and 16 of the Constitution. Is that it recognizes that a family of a deceased may be placed in a position of financial hardship upon the untimely death of the employee while in service, that it is the immediacy of the need which furnishes the basis for the state to allow the benefit of compassionate appointment. The pertinent observations of this court has been extracted as follows. Insofar as an individual facts pertaining to the respondents are concerned, it has emerged from the record that writ petition before the High Court was instituted on 11.
Mr. Saikya, how much time will you take? I've got a meeting at 1:50.
Lordship, in fact, today I was prepared to start at the very beginning because the earlier day they have closed it. Lordship granted me time, so I have
2 o'clock.
adjourned all the.
2 o'clock.
2 o'clock there is a batch cases regarding the delimitation exercise. I am continuing since yesterday.
Okay, yeah.
Tomorrow,
We'll
Lordship.
fix another just for you, that's all.
Because
If you are-
today it was fixed on me actually. They have
So-
taken away my time. My right has been taken away.
We'll fix another day
I
for you.
got all my 7 cases adjourned today because of this.
Okay.
From the court number 1, court number 11. Because the other day they closed at 12:50. Lordship said that in 10 minutes I won't be able to finish it. Therefore, Lordship gave today's date for my submission. In any case, Lordship, another date may be given, maybe after 23rd of this month.
Okay, right.
I was trying to close it, finish it today.
You fix the date. When do you want? You fix the date?
Lordship. Yes, 25th, no difficulty.
27th of? When do you want? 25th March?
25th March is a
March or April? Which is, you think April?
Tuesday. 25th March.
March.
If it is not inconvenient to the honor.
No. We have what? Fix the date. Put all this together, huh? There is one thing that is slightly troubling me.
Lordship.
Now, this OM that you have made, why couldn't it have been a part of your decision and all the thing?
Because
Individual.
our authorities or the department gave lot of emphasis to the Debabrata Tiwari's case because Debabrata Tiwari considered all the situations, all the circumstances in which a particular case may lie. And after that, the policy which has been framed by the Honorable Supreme Court, that has been just replicated. This policy is nothing of the state's
I
thought
know.
process. It
No,
was
but-
directly a continuation of the Honorable Supreme Court.
Because that Deborah Bhatta's decision could have been applied by the SLC or
Yes,
whatever.
for that, because now this SLC have different persons. They will interpret the judgment in different way. Then lot of more cases will come because there will be a violation. There will be deviation from to understand that judgment. Now I am understanding the judgment as a receiver decidendi. The other side is trying to project it as it's a obiter dicta. So for the lawyers also there are 2 views. For the officers there will be 100 views from various circumstances. They will interpret in their own sweet wisdom. If they want to benefit somebody, they will say some other judgment. If they want to deprive somebody, they will say that this is strictly applicable. We know our people.
Okay, but what about the OM? Now a decision is made by the court to reconsider the SLC decision or the DLC decision.
That
No.
let me complete my judgments because I have considered that part also. After certain situations, the court's order cannot be also implemented. That is the overall spirit of the judgment. If it has passed 2 years, our case is 20 years, 30 years old.
Okay,
One case supplementary by mention similar matter on item number 68 matter. May come along with those matter.
Item 68.
Diploma. Thereafter upgraded as LP school and accordingly upgraded as ME school. This ultimately is an amalgamated school. There is class 1 to 8 students are there. So school has 40 chor area. That was
Huh?
chor area, riverine area.
Okay, okay, it's in the char area. Huh.
Chor area. But some persons are those are not wanted to cross the river. Earlier they were filed an writ petition. On that writ petition, one interim was there. Under that interim order, they shifted this in the north bank of the river.
Are they?
North bank of the river.
The school was constructed in the North Bank.
Yes,
Huh.
now current distance we have no idea. They have to file affidavit.
No, no. You are the petitioner.
Yes,
What do you want?
we are wanting that school should be running at the origin side of the school.
That is in the South Bank.
South bank of the river. Yes,
But the school has already been built in the North Bank.
yes, so far my instruction is concerned.
Then who are you?
That is illegal.
Who are you?
Is it a guardian?
You are the guardian.
Yes,
What right do you have?
guardian.
What right of yours has been violated? Guardian of whom?
Yes, kindly have a look. Lordship, there is a page 21. It is the school. That is the school shifting order. Page 21.
Page 21. On the basis of report, so
Yes.
is hereby shifted to the new site of the North Bank, which is donated by us. So it has been shifted into the North Bank.
Thereafter, another order was passed by the authority. That is page 22.
Page 20?
22.
22.
22. Next page,
Kept in abeyance.
kept
Okay.
anywhere.
And then
Thereafter, they come to the court for staying.
who came to the court?
There were also some guardians. That all order Lordship may find.
They wanted the school to be in the South Bank or what?
And earlier, those were filed. They are from the north side. From the north side, of the river.
So
Yes.
they are from the north side of the river.
Yes,
And they filed this writ petition.
earlier they were also filed a writ petition.
So this WPC 1735,
Yes, Lordship.
that is by the North Bank.
Not there.
North Bank.
With the assistance of the school headmaster and others.
They filed this writ petition.
Lordship. And on in
So
that
they stay. This abeyance order was stayed.
Lordship.
And thereafter now a new building has been constructed. Is it
Yes,
in the North Bank?
Thereafter, another order, page
Ah.
27, Lordship.
27 years.
Page 27.
Ah.
Annex 6. Here is the another order is there, Notice in this case was issued on 14/3/2016 to the Elementary Education Department. On 10/3/2017, the court again passed an order directing the respondents in the Elementary Education Department to bring their affidavit positively on record within 4 weeks. And the matter, though listed today, no such affidavit on behalf of the respondent in the Elementary Education Department found in the record today. Failure on the part of the Director of Elementary Education, Assam, respondent number 2, and the District Elementary Education Officer, Dorong Mongoloi, the respondent number 3, in filing detailed affidavits in the matter on or before 4/12/2017, they have to remain personally present before the court on the next date fixed list on 6/12/2017. Accordingly, when the matters come listed on 6/12/2017, they withdraw the petition.
So they withdraw the matter.
Withdraw the
Okay.
petition, and in that petition, on that day, one order has been passed that Mr. So-and-so, on instruction submit that the petitioner do not want to praise this petition. Accordingly, this writ petition is dismissed as not praised. Impugned order dated 22/12, that is the impugned interim order, passed early instance vacated. So, ultimately, the captain abeyance order
Comes into play, correct.
So, whatever they doing in North Bank is totally illegal. That is why we are.
No. But that was only with regard to. No. That is only an interim order. There's not a final decision.
Yes. So, their affidavit is necessary. Actually, what they are one.
It's hereby reshifted. Now, where is the school running? It's in the North Bank.
North Bank, yes, now functioning from North
Then
Bank.
what
Actually,
remains?
But Lordship may kindly have a.
Look, Mr. Counsel,
Lordship.
look, let us think of it. There is a school.
Well.
There are students from the South Bank. There are students from the North Bank. So, you will never be happy if it is in North Bank. And if it is in South Bank, the North Bank people will never be happy also.
My lord, what?
So how can you play? So this is, you see, where is the right? where is your right that the school
lord,
should be in the South Bank?
yes, my lord. So what will happen to the students from South Bank and it's
They will go by boat.
and this school is only for the my lord, that side, not for this side. This side, another schools are there, my lord. Another ME schools are there. Only for their convenience, the teachers and other guardians, though were not wanted to cross the river, they, my lord, their assistant, this my lord, exercise is carried out. And for that, my lord, they
They don't want to cross the river. You don't want to cross the river.
lordship, otherwise,
What
no
to
right
do?
to Education Act. The purpose of the right to Education Act will be frustrated, lordship.
These are issues. You see, this is with regard. Yes, who are you?
I on behalf of respondent number 8, my lord.
Headmaster.
Yes. So where is the school running now?
My lord, the school is running in North Bank, my lord.
Since when?
My lord, from 2018.
18.
So today I am.
2018, now
Under
7
that-
years have
Under
passed.
that interim order, they may be, but we are on before the honorable court there. My lord, the captain evidence is there.
No,
My
no,
lord,
no, that kept in abeyance was kept in abeyance by the court. So that finished, that for that period. And that time they made it. Now that is the end of the matter now. That you cannot go to a to the Bullock cartage, you cannot go back. That's finished. You see, in any event, can this court decide whether it should be in the North Bank or South Bank?
my lord,
This
this
this decision, it's an administrative decision. It's nothing to do with the court. And just a minute, you are a guardian of a student.
Yeah.
Your student is what class is she studying? He or she passed out?
Maybe now past
Maybe.
20.
Correct. Let us see your writ petition. What have you said? Let us see. How are you? How are you interested?
Representation page 30, my lord. 30.
Just a minute, huh? Out here, you have said 6 year old, some 6 year, but nowhere have you said that your daughter or son is going. Where is it?
These are the well, guardians from and some public from the well, South Bank side. They will.
Mr. Counsel, there is only one writ petitioner. In this
Only
only one writ petitioner.
Lordship on being authorized.
Authorized? Sorry. This is not a PIL or anything. This, a writ petition, you can file a writ petition only if some right of yours has been violated.
Representation signed by the
Maybe representation can be signed by 20,000 people, but writ petition is filed by one person.
Yes, well.
Then?
I have mentioned it on being authorized.
No, where? Your affidavit.
Yes, paragraph 2.
Paragraph 2, what does it say?
Yes.
Let's read paragraph 2, page 14.
The paragraph 2 of the petition. That on being authorized, the petitioner has filed this writ petition.
Where?
Paragraph 2, my lord.
Yes. Please read.
That the petitioner along with other parents, guardians.
No. Which writ petition? This is your writ petition affidavit. This is your affidavit. In your affidavit, you have said that I so and so. That's all. You have not said you have. And how can you be authorized when those other persons are not parties?
Lordship,
Who are you?
my lord, the statement made in
No.
petition.
Their sorry statement is of no use. You can say anything. Your affidavit has to show whether you are authorized or not. How are you interested? Nothing is here. Oh. Let us see how you are interested. How is he interested? Is his son or daughter a school student or something?
Maybe on personal grounds, my lord.
I do not know. Maybe. I don't know. The only thing, nowhere has he said that my daughter or son is going to the school. Where have you said that? Your daughter or son or something is going to the school. Have you had? Page 5, para 2.
guardian of the student, madam. He has
come and file the details. No, there's nothing, there's nothing. Where is which son of yours or daughter of yours going to the school? Let us see the representation.
Yes, Malad. Page
Eh,
31.
Page 13,
30. Malad.
30.
Yes.
No, it's a problem. South Bank to alternate আছে।
Oh, Shiksha Mitra, so and so, so and so. Oh. No, there is nothing here. There is no statement that your daughter or son is going to the school.
Here it stated regarding the Malad, the page 31, in exercise of powers conferred by the Assam right of children to free and compulsory education rules 2011, the governor of Assam is hereby by this order dated so and so pleased to upgrade the efforts of LP school to upper primary school in the particular habitations.
Huh? So,
Now they are Malad, shifting the habitations from this side
it's
to
the
that side.
council. What is your right? What right of yours has been violated? No case. Okay, right. Yes, any submissions?
There is no acknowledgement in the representation also, madam. Page 30, madam. He has referred.
I don't know what right he has got, nothing. That nowhere has he stated that his son or son is going to the school.
Nowhere.
Huh?
Yeah, we said it.
He's no violation of traditional right. He doesn't say which class his son or daughter is going to.
Guardian of the case number.
Huh?
Yes, clear.
Huh?
You can not a guardian of the.
Yes, not a parent, nothing, nowhere. Nowhere is stated, right. So I dismiss your repetition. Heard, Mr.
Here, Malad.
A. Raman, learned counsel for the petitioner.
AK
Heard?
Azad on
Huh?
AK Azad for respondent number 8.
A.K. Azad appears for point number 8. Miss S. Tuti appears for
1, 4, 5, and 6.
1, 2, 5, 6, 7.
1, 2, 5, 6, 7.
5, 6, 7. Mr. P. appears for this point number 4. For SSA, who's appears for SSA?
P9.
Mr. P. appears for the respondent number 3. The petitioner's grievance is no, the petitioner has put to challenge the impugned order dated 31/12/2015 issued by the DEO Darang respondent number 5 by which the number 2 Darya IT Lengri Mari Char Upper Primary School is to be reshifted with immediate effect to the new site at the north bank of the Brahmaputra, which has been donated by one MD Bilal Hussain. For the newly upgraded MV school.
Yes, sir.
MV. MV. Huh?
Middle vernacular,
Middle?
middle vernacular school.
Middle. That will be what class? Middle vernacular school.
ME school category.
ME school will be what class from?
Class 6 to 8.
Class 6 to 8.
Yes,
So this was in 2015.
yes.
Here in petition,
2018.
in 2018.
Yes.
So this now 7 years have passed since 2000. So class 6 plus 7, class 13 by now.
Lordship is amalgamated school. Class.
Whatever. So even if you had a child, she or he would have been in class 6 in 2018.
Lordship.
By now passed out. Finish.
Lordship.
End of the matter.
Here is the demand actually from the public from South Bank, the shore area. This demand from the shore area.
You have only one writ petition.
After shifting of this school, that side will once again it will fall under schoolless, ME schoolless.
Anyway, whatever it is. I am not on that.
Purpose of the right to education is guarantee of the education.
Mr. Counsel, first of all, where is your child?
Lordship.
Where is your submission that there is a child?
Yes.
There is nothing here. Right. The facts of the case is that the petitioner is a resident of the south bank of the Brahmaputra, in which number 2 Dharya Khaiti Lengri Marichar Upper Primary School, the erstwhile number 2 so had been located. However, in view of the impugned order dated 31/12/2015, the said school was to be shifted to the north bank of the river Brahmaputra. However, while another order dated 13/1/2016 issued by the respondent number,
Same authority.
respondent number 5, the earlier order dated 31/12/2015 was kept in abeyance. Full stop. Next para. Some persons who were living in the North Bank and whose children who are living in the North Bank, being aggrieved by the order dated 13/1/2016 issued by the respondent number 5, file WPC 1735 of 2016 before this court. Full stop. This court state the impugned order dated 31/12/2015. No.
Yes, well.
Order
13/1/2016. Yes, well.
state the operation of the order dated 13/1/2016 while order dated 22/12/2016 passed in WPC 1735/2016, comma, on the ground that please lower your voice, Madam Devi. Please, your voice. Okay. You can go outside and have a discussion. What? on the ground that the impugned order dated 13/1/2016 was contrary to the report of the sub-inspector of schools dated 24/12/2015. WPC 1735 of 2016 was thereafter dismissed as not pressed while order dated 6/12/2017 and the impugned order dated 22/12/2016 stood vacated. Full stop. Next para. The petitioner's counsel submits that the petitioner represents a number of parents
Yes.
of children who are living in the south bank of the river Brahmaputra, who are against the shifting of the school to the north bank.
Yeah.
He submits that in view of the closure of WPC 1735/2016, while order dated 6/12/2017, the order dated 13/1/2016, which had kept in abeyance the earlier order dated 31/12/2015, was revived. Full stop. As such, the school cannot be allowed to, the school which has the school which has been shifted to the north bank in terms of the impugned order dated in
31/12.
terms, in terms of the impugned order dated
31/12.
page 21. In the impugned order dated 31/12/2015 in the year 2018
Yes.
cannot be acted upon. Full stop. That's all.
Yes.
The counsels for the respondents, on the other hand, submit that due to the stay of the order dated 13/1/2016 in WPC 1735/2016, the erstwhile so-and-so school has been shifted to the north bank and north bank of the Brahmaputra, and the same was now known as, what was that school? What school was it?
And it's Lengrimari.
Lengri Bari Char ME school.
Number 2 Dharia Khaiti, Lengrimari Shore, Upper Primary School.
No, ME school. Isn't it? ME school, Char ME school.
Well, it means 21.
MV school or ME school?
MB school.
Huh?
MB school, yes.
20?
Page 21, my lord. Page 21.
MV school, huh? MV school. Next para. No, continue. They submit that as the school has already shifted to the north bank and has been running there since the year 2018, the writ petition has become infructuous. So they also submit that there is no the averment made by the writ petitioner to the effect that he is the parent of a child who is a student in the school that has been shifted to the north bank of the Brahmaputra river. So I have heard the learned causes for the parties. The contents of the writ petition show that only the writ petitioner has filed the present writ petition. The affidavit filed by the writ petitioner along with the writ petition also clearly shows that the writ petition has been filed only by the writ petitioner MD Hanif Ali. The affidavit of the writ petitioner does not make any averment to the effect that the petitioner has been authorized by any other person
My lord,
to
authorized,
file. No, no, in the, see this,
my lord, authorized word is there, my lord. On being
authorized by whom?
authorized.
By
that is-
whom?
That is not mentioned and being
Ah,
authorized.
by whom? Donald Trump or who? Who is the person? I can say I've been authorized. By whom? By
Authorized,
some elephant?
let's say authorized by the other guardians.
What is that? What do I say? By any other person. And no name has been provided in the writ petition showing the persons who had allegedly authorized the petitioner to file the writ petition on their behalf. Full stop. There is no averment in the writ petition made by the petitioner stating that he is the father of a child who is going to the newly shifted school in the north bank of the river Brahmaputra. Full stop. In any event, the school that has shifted to the Brahmaputra is now known as the, is now page 21, is now known as the, is now an upgraded MV school. Wherein classes start from class 6.
But so, my lord, class 1 to 8, amalgamated school, this one.
1 to 8.
Yes.
Upgraded MV school.
Yes, my lord. LP school also there. ME
Okay, okay, cut that. Don't say that. Huh?
Yeah.
Full stop. In the case of Dash versus Dash, the Supreme Court has held that only an aggrieved person can approach a writ court for enforcement of his fundamental or legal rights which have been violated. Or if the state government has not performed a duty it has to constitutionally perform. Full stop. In the present case, the petitioner has not been able to show this court as to what fundamental or legal right of his has been violated by the shifting of the school to the north bank of the river Brahmaputra. Full stop. In view of the reasons stated above, this court does not find any ground to exercise its discretion to interfere with the impugned order dated 31/12/2015, shifting the location of the school from the south bank of the Brahmaputra to the north bank of the Brahmaputra. Full stop. The same is basically an administrative exercise to be carried out by the authority, a concerned authority. In view of the reasons stated above, the writ petition stands dismissed.
This one point may be observed as let- after shifting the school from south to that my lord, area, once again falls under the my lord, schoolless village.
No, 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 I'm not going to. You do whatever.
Plus.
Wait, please, Your Lordship.
This is
Yes.
this is a case where pertain to selection and appointment to the post of junior assistant.
To post of
Junior assistant.
junior assistant.
Earlier that was LDML, subsequently it was junior assistant.
Yes, so
What had happened in this case, my lord, on 30/10/2019.
13
30.
30 30 10
30/10/2019. The advertisement was issued by
for
the
for
principal
for junior assistant.
for junior,
How many posts?
but only one post.
Okay, junior assistant. Then
Junior assistant by the principal, and pursuant to that advertisement, the petitioner participated and he appeared in the written examination along with the other candidate. The result of the written test was declared on 8/3/2020, page 43.
8/3 2020 page.
Page 43. The written test held on the same day and the result also published on the same day. And the petitioner stood first.
Petition of page 43.
Yes.
Your Mohammad Nadim.
Mohammed Nadim.
Okay.
Then due to the COVID-19 method, the Viva test as well as the computer test could not be held. And subsequently, the
COVID, Viva and
Viva and computer typing.
computer. Yes, then
Subsequently, the inspector of schools on 2/9/2020, he was directed to the principal for holding the Viva as well as computer test. And accordingly, the admit card was issued on 19/10/2020 on page 48.
page 48.
48 is the admit card for Viva.
Admit card.
Yes, for Viva voice.
Only for Viva.
Only for Viva and typewriting. A computer and oral test. A computer and oral test for selection of candidate for the post of junior assistant will be held at New Golpara High School near the DC office, page 48. DC office, Golpara, on 31st October 2020 at 11 AM as per the criteria mentioned in the advertisement.
Okay.
The date for scheduled date was held on 31/10/2020.
Correct. Then
Then prior to that, my lord, on 30/10/2020, the principal has issued a notice, page 49, by which my lord, postponed the Viva test as well as the computer test. Subsequently, on query, it has come to know that this notice has been issued pursuant to the letter issued by the inspector of schools on 29/10/2020, which is at page 53.
correct.
And this letter has
Page
been
53, page 50.
Yes, page 51.
No, page 50 is there.
Yes, page 50 is the notice, my lord.
Acha.
That was issued by the principal.
Okay, page 53.
Page 53 is the letter issued by the inspector of
Okay,
schools.
okay. Page 49 is due to page 53.
Yes.
Yes, then
Then page 53, my lord, you have the letter issued by the inspector of school pursuant to that.
no,
letter,
this
my
is on the basis of the additional deputy commissioner
Yes,
Golpara's letter. Where
yes,
is
sir.
that?
That is page 51. Type copy is at page 51, my lord. Regarding appointment and posting at Krishnai,
Okay, then
I have challenged these input orders, my lord, as well as the notice.
so no Viva voice, nothing till now.
Nothing till now.
So this is of 2020,
2020.
5 years have gone.
Well, thereafter, what had happened? The deputy commissioner has filed an affidavit in opposition. This is my lord, running page number 58. They have annexed a inquiry report.
Page 58.
Page 58, well, running page.
Wait. 58. Page 58. Yes.
58. This is the affidavit filed with the additional deputy commissioner on behalf of the deputy commissioner. Their stand is that on the basis of a complaint made by one Abdullah Ahmed, who did not have participated in this election process.
Okay,
Pursuant to these complaint, my lord, the one magistrate has deputed by the deputy commissioner. Suddenly he visited the school and asked the petitioner to appear before him, and immediately he appeared and he gave him the question paper which he has written in 8 months back to write in front of him. And he has written, but he could not answer clearly all the questions because before 8 months he has given the written examination. On the basis of that, these entire letter has been issued to postpone the viva voce test as well. No
so
appointment.
they didn't believe you wrote it, probably. They did not believe you wrote the answers.
That's why. This is the inquiry report they have said, madam. But there another thing, madam, in the inquiry report they observed that maybe there was an anomaly and unfair means has been taken place in the examination, madam. To that effect, the inspector of schools, madam, has filed the affidavit in opposition, which is at page 54, madam, running page.
We are going from 58 to 54 to 54. Okay,
Yeah.
yes.
Malad, kindly come to page 57, para 11. That the deponent humbly begs to state that in the meantime,
57 is annexure
they
A.
have said there's nothing has been, Malad.
57 is annexure A.
Running page,
Para. Tell me the para.
para 11,
There's no para
Well,
11.
77, Malad, 77. Sorry.
70.
Two page
77.
number is
Ah,
written here, Malad. 77.
77. Para.
Para 11, Malad.
Para 11. Yes.
Bottom.
Yes.
That the deponent humbly begs to state that in the meantime, the aggrieved plaintiffs have filed the complaint petition against the written test of LDA assistant of Krishna Madrasa SS School. And so the then inspector of school Golpara by letter dated so and so directed the principal member secretary committee selection committee of the Krishna Madrasa SS to submit a detailed report on the complaint. Accordingly, a detailed report dated 2010-2020 was submitted by the principal Krishna Madrasa SS School, stating that the written test was done smoothly under the vigilance of the supervising officer and the inspector of school GDC Golpara. As per their report, there is no such anomalies and the unfair means has taken place in the examination. More so, my lord, my submission before your lordship is that the deputy commissioner has no role at all. He has no jurisdiction to interfere with the selection process held under the rule 2003 rules. This selection process has been taken place on the basis of the 2003 rules. In 2003 rules, there is
That's
no
all. That's all.
Yes, but to that effect, one judgment is also there of this honorable court, madam. Out of the similar facts and circumstances, wherein it has clearly stated that the deputy commissioner has no jurisdiction to interfere into the matter. In the meanwhile, during the pendency of the case, my lord, the state government has issued an advertisement centrally, but the petitioner was not aware about that. When the candidate has been appointed against this post, my lord, then only the candidate petitioner came to know that one candidate has been appointed against this post.
So the post is gone.
No, my lord. Then I have challenged the appointment order of that candidate, my lord. When challenged, after received the notice, my lord, this candidate has resigned from the post.
That's
Now,
the,
he resigned. She resigned, my lord. She resigned, and now the post is lying by them. This is the present position, my lord. And in the they have also taken the stand.
how much more time are you going to take?
My lord,
How much time are you going to take?
sometime, my lord.
Sometime. What is there to say now? I've got tribunal is going to sit at 3:30. I've got to rise. You've got to tell me how many more minutes will you take?
About 10 minutes.
Why? What is there to say? Wait. Yes. What is the case now?
My lord, initially against this selection, my lord, complaint has been received by the deputy commissioner. Accordingly, Deputy Commissioner, my lord, he has conducted an inquiry and found some genuinity, and he has submitted a report, directed to submit a report, my lord. And this is, my lord, in our affidavit, my lord. And the Deputy Commissioner, my lord, he called the candidate, my lord.
Have you cancelled the entire selection process?
My lord, even my lord Viva and no, my lord, even my lord Viva, and that's my lord.
No, so have you cancelled?
Yet to be conducted, my lord.
Mr. Counsel, I'm not on that. It's a very simple thing. Have you cancelled the selection process? You have not cancelled it. Then you complete it.
Yes, that's right.
My lord, because my lord,
In the meantime, my lord, the selection of grade 4 was taken by the Assam Direct Recruitment Commission for analogous post.
When?
My lord, the act was
And has anyone been appointed?
2021.
that subsequent advertisement issued in 1/3/2022.
Yeah.
Subsequent advertisement by the state level recruitment commission. And accordingly, one candidate selected and she has appointed on 25/5/2023.
25/5/23.
25.
But she has resigned.
Subsequently, she resigned. my
Then?
lord. Against that appointment, my lord, petitioner preferred a repetition, my lord. Subsequently, that repetition withdrawn by the petitioner.
Correct, because she has resigned.
Yes.
My lord.
Now the issue is this.
My lord.
The advertisement was issued by you sometime in 2019. Selection process has started, it has not ended. Have you taken a decision that the advertisement is cancelled or the selection process is cancelled? If you have not done it, then you carry on. That's all. What
My
remains?
lord.
Even, my lord, the subsequent advertisement which was issued pursuant to the Act, my lord, 2021.
No, the issue is very simple. The issue is this.
Yes,
The issue is if there is an advertisement for filling up a post,
yes,
selection process has started, and if
That
there
should
is
be
no decision by the respondents that the selection process is cancelled or the advertisement is cancelled, then you take it to its logical conclusion.
Yes.
That's all.
yes.
Why should we go into other aspects?
No, but herein in this also written that any recruitment process for which advertisement have been issued or which is at any stage of the recruitment shall be completed as per existing provision.
Where? Who has said
In
that?
this act, my lord. The subsequent act on the basis of which they have issued the advertisement.
Instructions from the inspector and moreover, my lord, inspector has.
This is the act, my
filed
lord.
the affidavit that in that circumstances, they had not mentioned regarding this matter, so I have to take.
Section
instruction
21, my
regarding
lord,
the cancellation of the.
Right. Heard, Mr.
RS.
R. Islam, lawyer counsel for the petitioner. Also heard Mr. P. Saikia
I am for the deputy commissioner, my lord.
for the deputy commissioner,
My lord.
and Mr.
You shall not for secondary division.
U. Sharma for second.
3 and 4, my lord.
Next para. The petitioner's case is that an advertisement dated 30/10/2019 had been issued by the
Principal of Krishnai High Secondary School.
principal of so high secondary school for filling up one post of junior assistant. The written examination results were declared on 8/3/2020, wherein the petitioner secured the first position. The Viva Voice and computer typing tests were adjourned due to the COVID-19 pandemic. However, the inspector of schools, by letter dated 2/9/2020, directed the principal of the school to hold the Viva Voice test and the computer typing test. The petitioner was subsequently given admit card for participating in the Viva Voice and computer typing test on 31/10/2020. However, The viva voce and computer typing tests were postponed by the principal of the school by notice dated 31/10/2020. Oh, I've already said that, no?
30/10.
30/10/2020, which was made in pursuance to letter dated 28/10/2020 issued by the Office of the Deputy Commissioner, Golpara. The petitioner's counsel submits that in terms of the what rules? 2003 rules, what is the full form?
Assam Secondary Education Commercialization Service Rule 2003.
2003, The Office of the Deputy Commissioner has no role to play in the selection process for filling up the post of junior assistants. In the office of the, in the school.
Yes.
Further, the affidavit in opposition filed by the inspector of schools, bracket, respondent number 5, is to the effect that the written test was conducted smoothly. What have I said? The last sentence? Is to the effect that the principal of the said school in his report dated 20/10/2020 had stated that the written test had been conducted smoothly under the vigilance of the supervising officer and inspector of schools, GDC, Golpara. The next paragraph, the petitioner's counsel submits that though the vacant post of junior assistant had been filled up pursuant to an advertisement dated
My lord, the advertisement dated. But date is not given. My lord.
pursuant to advertisement issued by
Issued by the State Level Recruitment Commission
State Level Recruitment Commission.
for class 3 and class 4.
The selected candidate, the selected/appointed candidate had resigned from the post as the same had been put to challenge by the petitioner in WPC number
In WBC 6554/2023.
6554 of 2023.
3.
Next para, the petitioner's counsel submit that the post of JA is still vacant as on date, and as there is no cancellation of the advertisement dated 30/10/2019 or the selection process made in pursuant to the said advertisement, the selection process has to be taken to its logical conclusion. Accordingly, a direction should be issued to the respondents to conduct the viva voce test and computer typing test pursuant to the advertisement dated 30/10/2019. That's all.
Well, more particularly the respondent number, Inspector of Schools. My lord.
Huh?
Direction may be given to the Inspector of Schools. My lord.
No. Yes,
Respondent number, my lord, 6.
that is only your submission. Now I've got to write their submission.
Yes.
Yes,
My lord, that after the complaint, my lord, being a district administration, my deputy commissioner have to look into that complaint filed by the person, my lord.
Mr. Council,
And my lord,
the 5 years have gone.
no, my lord, regarding the appointment, my lord, that rule 5C, my lord, is specified, my lord. Rule 5 subsequently, my lord, is power of the deputy commissioner in 2003 and
So
2012. my lord,
what
is also there.
decision have you taken? Who is appearing for the deputy
Moreover, my
commissioner?
lord, that 2003, that has already been superseded by 2018 rule, my lord. Now qualification has changed, my lord. And once, my lord, there is an
Well, you
observation,
see,
my lord,
that is coming from you.
my lord.
What is coming from the deputy commissioner? Nothing.
No, my lord, even that inquiry report, my lord, is clear, my lord. Because, my lord, infirmity is there, my lord.
But you are not acting upon the inquiry report.
No, because,
It,
my
it
lord,
is like this. It is like this. You are the SP. You have one constable working in your office. There is a report that your constable has murdered some whole family. You are not doing anything with the report. You're keeping it in your drawer and you're allowing him to work.
my lord.
Okay? Then you have to give that fellow his salary. You cannot keep it. You have to treat that person by following the process. Now here, slightly different but similar, in a way that advertisement has been issued, everything has been done. Only thing is that the Viva voice and computer has to be carried out. Now you are not doing it because of some report made by the deputy commissioner, which is inside his desk. He is not acting upon the report.
That part
Then-
to be, my lord, carried out by the concerned administrative department.
So when
Because,
are you
my
going
lord,
to carry out? 5 years have passed.
my lord,
How many years do you want? How many years do you want?
apart from that, that finance retention was given to the new post, my lord, as per the new appointment, my lord. Now we have to again take the finance retention, my lord.
No, that is a
Therefore, my
different
lord,
thing.
I am
No,
saying
that
my lord,
is a
it should
different
be
thing.
Readvertisement by taking the consideration of this Annexa 4, my lord, which is the report, my lord. Some infirmity is there, my lord. That as on that
Mr.
infirmity
Council,
that
there
we
is
have
an
submitted,
infirmity. Please take a decision.
my lord.
There is an infirmity. Take a decision. You're not taking a decision.
My lord, that part, my lord, my learned friend will.
Who is for the
instruction,
DC?
my lord. No, Deputy Commissioner.
You're
for
the
Crime
DC.
Investigating.
The report is with you.
My lord, report is with me, my lord.
Then
Accordingly,
what
my
are
lord,
you doing with it? You're
that
keeping it in
report
your
is-
back pocket.
That has, my lord, communicated to the concerned department,
Then they are not doing anything.
my lord.
And moreover, my lord, in the meantime, they have filed this late petition, my lord.
Naturally, they will file. Why will they not file? They have to file.
And thereafter, that advertisement is pending.
Huh?
Thereafter, my lord, that process is pending.
What process is pending?
In view of this late petition, the selection process has been pending. In the meantime, my lord,
So you carry on with the process.
No, my lord, difficulty is that, my lord.
Huh?
Once, my lord, that post, my lord, advertised, my lord. New financial retention is there, my lord. That has taken for the other candidate, my lord.
Where have you said that in your affidavit?
My lord, that affidavit, my lord, subsequently, my lord, brought by the department, my lord. The state level
They will
recruitment
do
committee,
whatever they have to do. You do whatever you have to do.
my lord.
You cannot argue for them. Can you make submissions beyond your pleading?
Indian media, please. Notice taken again.
Look, in meantime, my lord, the new selection process was carried out by the Assam Direct Recruitment Commission.
When?
In our affidavit, it is mentioned here, madam.
When?
No.
Early in 2022. 1/3/2022.
Yes, my lord. A new advertisement was occurred 1/3/2022.
20?
Two.
That is, didn't you hear what he was saying?
So, my lord, I have to take instruction regarding whether that earlier advertisement was cancelled or not by the department.
It's not cancelled.
Not cancel, my lord. Affidavit they have, recently one affidavit they have.
But he says that the 2003 Act has been replaced by the
That has
2018
Well,
Act.
that act I have given, my lord, the Direct Recruitment Act. In that act itself, my
And
lord, section
qualification-
21,
Education qualification
can you
also
see
changed
section
in the new
21?
act, my lord.
section 21, I have
Yeah.
given just, my lord,
Yeah.
and that over. Section 21, any recruitment process, one, any recruitment process for which the advertisement,
As per the provision.
yes. And even, my lord, regarding the interference of the deputy commissioner, similar matter, my lord, the junior assistant candidate interfered by the deputy commissioner, this honorable court passed in judgment, my lord. This is reported in 2017 to JLJ 451. It's clarified that DC has no authority to interfere into the selection process of the junior assistant concerned. The judgment is here.
Yes, so the counsel for the respondent submit, what is your submission?
My submission will be that, my lord, after my lord, that complaint, my lord, DC had raised the complaint, my lord, DC has verified, my lord, and
What
found-
is the complaint? What is the complaint?
my lord, that's a report, my lord, I have enclosed as an Annex 4, my lord.
What is
That-
it?
that is
What does it
report,
say? Page?
Page number, my lord, 61, running page 61, my lord, in our affidavit, my lord. Thirty 2022, my lord. A field inspection was performed on 27/10/2020 at so-and-so school.
Page
And-
61, page 61, there's no
Running
report.
page
Running
61,
page,
my lord, in our affidavit, my lord.
Where is
Yeah, I
page
have the line.
Affidavit dated, my lord, 18 August 2021.
61? Page 61, this one.
My lord. Report, my lord. In the middle point, my lord. A field inspection was performed on 27/10/2020 at so-and-so school, and Mohammad Nadim, his the petitioner, was called to the spot. He was asked to write the same question paper at the wrote on 8/3/2020. His score was only 16.50 out of 80 on 27/10/2020. Observation. As the candidate Mohammad Nadim, that is the petitioner, got only
You got only
16.50.
16.50 marks.
Well, that is suddenly he called him, given some questions 8 months later, after 8 months of the written test. my lord. That cannot
How
be a
can you
base.
do this? How can you do this?
That cannot be done. my lord.
Okay, what have I said? Mr. P. Cycle, learned counsel for the respondent number.
Number 4 and 5. Three and 4 minutes.
3 and 4, submit. That a report had been made against the petitioner by the Assistant Commissioner, come Executive Magistrate on 6th February 2020, wherein the petitioner had been asked to write the same, had been asked to write answers to the same question paper that he wrote on, was asked to write on 27/10/2020, answers to the same question paper that he wrote on 8/3/2020. The petitioner, however, got only 16.50 marks out of 80, while in the exam conducted on 8/3/2020, the petitioner had secured 70 marks. The same created a doubt as to whether the petitioner had really as to whether there was any foul play in the marks secured by the petitioner on 8/3/2020. Correct? That's all.
My lord. Therefore, my lord, the deputy commissioner has view to reconduct the inquiry.
Huh?
Therefore, my lord, that inquiry deputy commissioner, my lord, he has view to reconduct the inquiry, my lord.
He has,
He has a view, my lord. that-
as such, the deputy
re-
commissioner is having a review. Where is that pleadings?
The understand is the view that the benefit of doubt should not be given to the Mohammed Nadim, that is the petitioner. A retest should be conducted under.
As such, the DC was of the view that the retest should be conducted. That's all.
My lord.
That's all. So retest, yes. Mr. What? What do you want? Mr. U. Sharma, learned counsel for
For secondary education department.
Secondary Education Department submits what?
My lord, after the return test, my lord, as the deputy commissioner directed the stop on the conduct of the computer test and oral test by the inspector of the school.
Submits that in view of the report
Yes,
submitted to the deputy commissioner's office,
yes,
the entire selection process has come to a halt. That's all?
yes.
And my lord,
Okay.
new appointment, that part also may be
Huh?
taken into account, my lord. The new advertisement, that part also taken into account, my lord.
What do you advertise? That's finished.
My lord, subsequently, my lord, state level recruitment board issued the advertisement against that post, my lord. Petitioner has not challenged that, my lord, advertisement.
Not against this post, my lord. That centrally they have advertised, my lord.
Whatever is there, my lord, if
Central
petitioner
they
is
Right,
interested in a
right.
particular
List
state, my
this
lord.
matter again. List this
Central
matter again.
advertised.
Give a date. No time. Give a date. No, we'll finish. Anytime. Or make it in April. Next year to March. Just write it down. No? Just order you write it
Much
down.
of.
Yes. What is to be done?
I am praying for some more time. There is an instruction, my lord. It is still pending with the department, my lord.
Okay, Mr. N.J. Khatanier is granted a further 2 weeks' time to obtain further instructions. List this matter after 2 weeks. Okay. Yes, what is this matter?
The selection to the post of headmaster in provincial high school in BTC area. We are the senior most teacher, but junior were
No
appointed.
time.
Last chance was given to the BTC authorities to file the affidavit and produce the record. Till date, they have not filed affidavit, not was a record.
With me, I have sent it back to the record, my lord. Some more time to get the entire instruction, my lord. In the meantime, my lord, the private respondent have filed the affidavit. I am also entitled to that affidavit, my lord.
Yeah, filed.
I have not received the copy, my lord. This should.
Give them copy. Yes.
What's my lord? 2 weeks time, I will file my
Lordship,
affidavit.
my submission to the Lordship, some of the petitioner is going to return. If they taking
2 weeks
time,
time,
like
my
this,
lord.
also 12 days has been taken.
Anyway, look, right. Miss, on the prayer of the parties, on the prayer of Mr. S. Bora, who submits that he will positively get the records back by the next date, list the matter on. Today's what date?
18/3.
When?
Let it be second week of April, my lord.
No, Lordship.
List the matter on 8th.
Lordship, interim order. will
Interim order to continue to the next.
Negligence.
Yes.
Only because of a typographical mistake, Lordship.
Yes. Who is for the finance?
As per my information, my lord, today finance has given the concurrence, my lord. I have seen the.
Yes.
We have already given the concurrence, lordship. Today we had given the concurrence.
Okay, right. So what is to be done now?
Lordship,
Fix it after 4 weeks, my lord. In the meantime, I will obtain instruction.
no, because we have already given the concurrence, lordship. So
Why 4 weeks?
Now it is on our.
Why 4 weeks? Why so much delay? Right. Mr. H. Ali has submitted a letter dated 18/3/2025, issued by the Secretary to the Government of Assam Finance Department to the Undersecretary to the Government of Assam, no, to the to the
this has been,
not letter, don't say, has submitted a
endorsement clause.
note dated 18/3/2025 to the Department of School Education Secondary Branch, stating that Finance (SIU) Department has accorded its concurrence for correction of the post-creation number in compliance with the order of this court. Accordingly, while issuing appointment order, department is to ensure that appointment will be only prospective and no arrears salary will be paid. Full stop. Mr. N. Khataniar, N.J. Khataniar shall obtain instructions by the next date as to whether the petitioner has been appointed to the said place. List the matter. Give in the first week of April. 4th April. You can take a photo of this if you want, the two documents.
May it be pleases your lordship, as per telephonic conversation, your lordship, hearing report is yet to be signed, your lordship, and
What has to be signed?
hearing report, that hearing has been concluded, your lordship, on the last occasion, and pertaining to that, your lordship, hearing report is yet to be signed, and due to some technical e-office is not working properly, they could not be signed it, your lordship.
Who is to sign? The officers?
Deputy Director.
Why is it so difficult to sign?
E-sign is not working properly. So kindly, I pray for 4 weeks time.
No,
your
no,
lordship.
no, no. This is too much. It's too much. 23 matter, what 4 weeks? Ms. P. Das shall inform this court as to why the arrears salary has not been paid to the petitioner and as to whether the e-signature of the and whether the signatures of the concerned authorities have been given for the hearing.
Hearing report.
For the hearing.
Yes.
For the hearing report.
Hearing
In
has
the
been
hearing.
concluded.
In the hearing report. List the matter on. Give first week of April.
7th April. 65 and 66.
Deeply obliged.
Yes. So has charge been?
Yes, lordship.
So this matter become in fact.
Matter may be closed, lordship.
Right, right.
Both the
Contempt
parties.
petition. Heard Miss
P. Bora.
P. Bora, learned counsel for the
Petitioner.
petitioner, and Mr.
N.A. Majarbuya,
N.A. Majar Buyar for
respondent number 4.
respondent number 4. Miss,
Appearing on behalf of GP.
you got it? Counsel for respondent number 1. So the counsels for the parties submit that the contempt petition can be closed in view of the fact that the interim order passed in WPC 6979 of 2024 has been complied with.
Lordship.
In view of the submissions made by the counsel for the parties, the contempt petition stands closed. Next, in the writ petition is also who's
Yes, lordship.
it's yours, no?
Yes,
So
lordship.
this has become infructuous.
Yes, both the matter may be closed.
Then in the thing, same parties out here, Mr.
N.A. Majarbuya for
N.A. Marab appears for the petitioner.
for the respondent number 4 in the writ petition.
In the writ petition for whom?
Respondent
Oh,
number 4.
yes. Okay, again, out here. In the contempt.
I am the contempt now.
For both the cases there for the.
Actually, you're the
I'm
contempt now. You're the so same are the same parties. Okay, same parties.
For the respondent number 1, 2, 3 in the writ petition.
Oh, in the writ petition, Mr. U Sharma for 1, 2, 3. Mr. Badar Buyan for respondent number
Respondent number 4.
4. And you're for? You're not there in the writ petition. Okay, right. The counsels for the parties submit that the writ petition has become infructuous in as much as the post of in charge headmistress has been handed over to the petitioner. Accordingly, on the in view of the submissions made by the counsel for the parties, the writ petition is closed as infructuous.
Deeply obliged.